make a submission, my lord. Serial number 40 is 40. The order under challenges was passed by the one of your
We have to
lordships.
put a respondent in the same matter, my lords.
That's all.
So
This-
14 not to be placed before the bench where one of us interpret Honorable Mr. Justice Krishna Dixit, Brigadier is a member.
I appear for the respondent in the same matter.
21 also.
21 also, 21 same order.
I think there are 3 matters today in which I have passed out. One more matter.
So two.
Somehow I feel.
21 also same. 21 and connected both. Yes. Now as far as the submission of memo is concerned, all are granted to be listed up after 10 to 15 days.
One matter, one HHN matters.
My lord, the matter was listed last week. It's a PIL. I moved for urgent interim relief. My lord, directed to be listed the next day. It didn't reach, my lord. It's
Madam,
regarding demolition of an
as per the system, the matters will be listed within 5-6 days after the office objection is removed.
My lord, it was already listed once, my lord. On the said date, it didn't reach. I was moving for.
So we are
urgent
telling
interim
after
relief.
10 days you will list it.
My lord, I'm moving for interim relief, my lord. The issue is they started digging around the road and they've broken the sewage pipe. It's leading into the stormwater drain, my lord.
10 days nothing will happen.
My lord, my request this week it may be listed.
After a week, after a week.
Matter pertains to recruitment of junior engineer, my lord. Shortly, my lord, the recruitment list would be finalized, my lord. There is some urgency in the matter.
What is the matter?
My lord, matter pertains to recruitment of junior engineer of KPTCL, my lord. The issue involved is with regard to
That can wait.
revision of
Process has started.
stances prospectively. My lord.
Process has started
Process has started, my lord. Shortly, it will be finalized, my lord. There's some urgency.
after 10 days,
Just for a week.
not possible. Now all these memos should be in respect to matters filed sufficiently long. Recently filed matters, no memo to be submitted. Because we are trying to ensure that all are listed once the office objections are removed.
This matter appears to the respondent where I'm moving a memo.
Hmm.
Because in this matter, it's a old matter.
Hmm.
His lordships have been
Hmm.
have passed an order in the writ petition saying that not before me because your lordship.
Then same thing will happen.
Same will happen. Which matter it is?
This is pertaining to writ appeal.
Is it posted before us? Not posted.
It's not, it is before your lordship's bench. So there is an extreme urgency in the matter. That is why I'm moving it.
So it should come first here, then we'll say no.
Yes, sir.
You wanted to list it.
It should be listed so that appropriate orders may be passed so that it will be placed.
So
before
list
other
it within 2 days.
First of all, and details.
Remind me once it is listed.
Yes, ma'am.
Remind us rather.
First of all.
Lords, one HHN matter, one writ petition pertains to HHN matter regarding admission to UG NEET medical courses. My lord, the reasons for rejecting my application in the last academic year is petition was claiming category under the Scouts and Guides result category. The Governor's award was issued. Presidential award was not issued for the reasons of the COVID situation. In the last academic year, I have filed the writ petition. Since the academic year has come to an end, it has become infructuous. The present academic year will also start at any moment. I have filed fresh writ petition challenging the rule which prevent me from getting the admissions under the Guides and Scouts category. At any moment, it may be listed for the limited purpose of issuing notice. At any time, my lord, academic year will commence and they will issue admissions notification. Again, it will become infructuous.
Medical matter.
Medical
Medical
matter.
admission.
Yes.
Next week we'll.
No, no, I have already lost one academic year, my lord. Any
Said that.
Monday, my
And
lord.
this academic year is yet to begin by your version.
Yes, yes.
Therefore,
My
next
lord,
week.
before that, unless the notice is ordered, I have to, that
26,
rules I have to argue
26 or
on.
27 you list.
Yes, please. 26th.
The lordships kindly, my lords. My lords, during the pendency of writ petition, my lords, stay was granted to not dispossess the property, my lords. Now the writ petition is dismissed, my lords. Now they are dispossessing from my owner, my property, my lords, without due process of law, my lords. And the police are also aiding on this, my lords. My lords may kindly have it. There is an extreme urgency, my lords. The lordship may have it tomorrow, my lords.
Next week. Your petition was dismissed or whose
Yes, my
petition?
lords. My petition was dismissed, my lords.
And there is a stay during the pendency of the petition.
Yes, my lords.
Not in this matter.
All. You're filing appeal.
Yes, my lords. Please.
Listed within
Permit.
Monday.
Monday, my lords.
Yes, this case, my lord, the complainant is not getting the pension and pensionary benefits,
It will
service
listed within
benefits, my
10
lord.
days.
He has
Within 10
retired in the year 2022, my lord.
Maybe.
My lord, in one submission, my lord. View of the interim order passed in interim order is there for learned single judge order, my lord. Your lordship has granted interim order in terms of 27/11/2015 order, my lord, in the case of writ appeal number 2476, which is for hearing before your lordship, my lord.
The bench.
Yes, my lord. In that view, my lord, the registry is not posting this matter. Earlier, I have moved the matter, my lord. The specific direction is that, my lord, one my submission, madam, that stay is insofar as unaided period is concerned, my lord.
That is on merits. Now only why it should be posted is the focal point.
After
Well,
2
I am
weeks,
here, aided period is not.
after 2 weeks, list it up.
22
All-
years
all-
retired in the,
All can't be posted at a
not
time.
getting pension is also.
So within 2 weeks, we'll take up within 2 weeks,
Please,
not before 10 days, but yes.
Your Lordship,
kindly,
I
madam.
appear for the respondents in item number 36. I seek a short accommodation. I have informed the other side as well.
I appear for the appellant in this matter, my lords. We don't have objections. Maybe just be posted on a specific date, my lords.
Posted
My lords, on the 1st of or the 2nd of April, whichever is convenient.
1st April.
My lord, very good.
Obliged.
Serial number 42, my lord. I'm appearing for the appellant, my lord. Request for short accommodation.
Serial number
42, my lord.
42. Why do you want time?
My lord, on record is not keeping well, madam. I'm a proxy counsel, my lord. On record advocate is not keeping well.
2nd April.
Yes, sir. 42, madam.
2nd April.
Yes, sir. Appeal. 2nd April. Please, much of them.
See, for motion, you should not take much time because your friends will be waiting. You have said that, you have said that. We have already, other day, I remember every word we remember. You said there were 2 writ petitions, 1 writ PIL we have withdrawn. Matter was posted on Friday. Then you asked for Monday. Honorable Chief Justice said every word we record, and it is recorded there also. I am only reproducing those things. Therefore, don't embarrass us much.
Yes, my lord.
Will be providing the electricity.
Provided.
Please, madam. 1 week time may be granted.
Will provide within 1 week.
It may be recorded, my lord. Let them, it may be recorded.
Learned
Otherwise-
advocate, Miss, what is your good name?
Ashwita.
Ashrita.
Yes, madam.
For the respondent stated that, respondent accused stated that the electricity connection in the shop of the complainant will be provided
Please, madam.
within 1 week,
Please, madam.
and the directions of learned single judge will be complied with. Full stop.
Post
You have the
after-
statement,
Office of.
Date may be provided, my lord.
nothing survives in the
No, my lord. Otherwise, my lord, they won't
proceedings,
provide.
comma, the
This is the,
respondent accused shall
for the
abide by the
last 2
state.
years, my lord.
respondent accused shall abide by the statement, disposed of accordingly.
They have said if they do not do it, amounts to aggravated contempt. Why do you?
Why do you, now, that small thing will be, they will be, you pay the charges, whatever charges. to be
I am
paid.
ready to pay the,
Do it. Learned advocate, Mr. Narendra Gowda, for the complainants at this stage stated that he will complete the formalities of having the electric connection, including the payment, including that the complainant shall pay the charges as may be required to be paid.
Much obliged, madam.
Ajit Kalyan.
Lords, I appear for the complainants in this matter, my lords. I seek for a short accommodation to comply with the offer.
2 weeks,
Yes, ma'am.
2 weeks. So 2 weeks time is granted to comply with the official provisions. Failing with the complaint shall stand dismissed without reference
Yes,
to or order of the court.
Much.
Serial number 3, Mr. Raghavendra BS. Raghavendra BS, any objections?
Same order, 3 weeks. Give 3.
Serial number 4, the Shilpa Rani.
Weeks time may be granted, my lord. Comply officer.
Time,
Please,
what
ma'am.
time?
Weeks, my lord.
3 weeks.
1 week, ma'am.
1 week.
Please.
Right one. So then it will automatically get dismissed if you don't comply with it.
No, my lord. I'll comply it in weeks, ma'am.
So we are granting 2 weeks, don't.
Peremptory
Two
orders. Not one doing.
So that no further time can be. 2 weeks. Yes.
This is serial number 5, Mr. Nagendra Naik. Mr. Nagendra Naik.
Appearing for the appellant, my lord. Seek time for 1 week to comply with the objections, my lord.
2 weeks.
2 weeks. Much obliged.
Do earlier, but we are granting 2 weeks.
Number 6, Mr. Doreraj, BH. Doreraj, BH.
One objection which is raised by the office with respect to the bylaws of the writ appellant, which is in Kannada, which is not relevant to the adjudication, which is not referring to any documents in the bylaws.
All petitions are transferred to Supreme Court.
My lord, these matters have been transferred to Supreme Court. Unfortunately, my lord, while there was an interim order granted by single judge, that was not seen, and a matter which got dismissed for non-prosecution was held, and an order was passed by the Karnataka government, where making all the doctors of radiology not operative because of the amended section 3 rule.
Rule 3.
Yes, my lord. Today, the appellants are handled not to practice because of this interim order, sorry, because of the single judge order and the government order which has come in force.
So we can do little in this matter when everything is before. You go before the Supreme Court.
My
Only
lord,
single judge given
my lord, the
liberty.
reason is, my lord, after filing the writ petitions, the central government filed the petitions in Supreme Court. Now I am constrained by the petitions filed by the central government, and I'm being asked to go to the Supreme Court. Other than that, the matters were adjudicated, interim order granted. All my submission is, my lord, let there be an interim order and matters may get transferred, because the matters are pending before the Supreme Court and no adjudication has been happened there. Now, unfortunately, my hands are tied and I'm not able to practice here, my lord.
By whatever way the matters, other matters go to Supreme Court, we can't touch now.
My
Only
lord,
because
while
the Supreme Court has on its own solicited the listing, or
my lord,
at the instance of this government of India, as you are saying.
I oblige, my lord, but there was an interim order. Let there be a protection for me to the extent to practice, my lord.
You can grant time to remove the office option, but the stillborn matter. 3 weeks.
If it is again, I will argue, my lord, I'll try to convince. If it's 2 days, I'll try to comply my office objections.
Never you complete.
Oblige, my lord. If a date may be given, my lord, I'll complete. A date may be fixed, my lord, I'll comply in 2 days.
You are granting how many time? 2 weeks, 3 weeks?
1 week, my lord.
1 week.
Oblige, my lord.
Number 7, for third time, Mr. Siddhappa BM.
There is for 2 week time to do the needful. Only Aadhaar copy is not legible. I have to do it in
2 weeks. This is part of it.
Orders, number 8. Mr. CA Venkat Reddy.
My impleading application, Malak. I filed this impleading application for the reason. Now it's a PIF filed by the petitioner. At the instance of respondent number 8, 7 and 8, they are the developers.
Who are you? You are
I'm the person who have been granted this land in the year 1979. And I'm in possession and I paid all the taxes, everything. And now by filing this writ petition, the podi and durastu, which the authorities have to do it, it is coming in the way.
You have you served a copy on the other side?
Who appeals?
One Mr. Venkat Reddy is the petitioner's advocate.
So you are in possession of this land.
I'm in possession, I'm cultivating now.
Cultivating.
Podi and durasti is to be affected. Because of this writ petition, the revenue authorities are giving a lame excuse. This writ petition is pending, we cannot affect this podi and durasti.
Any order is passed in this matter?
No order is passed, my lord.
Then only if some order is passed, that comes in the way of Podi and all, then you become necessary part.
I'm wrong in my making. I did not verify the what order or what is the earliest order. I'm wrong in my statement. If I can verify tonight.
Where is I?
whether your land is included in that 54 acres, 38 guntas?
Please, my lord. It's
Where-
part of,
In which paragraph you have stated in your application?
in my implementing application, my lord.
Ah,
My lord, in the para 2, submitted that government of Karnataka under a scheme of land grant rules in the year 1968 was pleased to grant certain extent of land in zone number 81 of Vittasandra village. The grant was made in the year 1979. Grant check cultivation certificate issued to all the grantees in the order in order to evidence the grant. The revenue records RTC here is produced marked at annexure A2, A4 mutation extract so and so up to annexure AC. Submitted ever since the applicants are in lawful possession enjoyment of the property, the revenue authorities have issued necessary document, but Port and Durust was not affected by the revenue authorities. In this regard, the applicants approached the Deputy Commissioner, respondent number 3, made necessary application. Respondent number 3, Deputy Commissioner caused notice to all the applicants. So and so called upon to produce the original document. The petitioner appeared before the respondent 3, Deputy Commissioner produced all the original document for verification. Office of Respondent 3, Deputy Commissioner issued notice to applicants and brought to the notice of the applicant that writ petition number so and so is pending before the Honorable High Court of Karnataka. Immediately, applicant approached this Honorable Court and obtained information and copy of the writ petition. Submitted that writ petition filed by one Sri Munraju and Nagaraju of Bangalore City and another from Yelahanka at the instance of one
Yes.
developer, so and so.
So nobody is for the public interest petition.
Nobody appears, my lord.
Nobody appears.
Nobody appears. I said a copy way back on.
How can it?
Correspondence 1 to 7.
How can it?
Petitioner
State,
not
state have to protect our interest. 7 to it is served on the petitioner learned advocate.
So order in IA. Heard learned advocate, Mr. What is your good name?
M. Shiva Prakash.
For the applicant and learned additional government advocate, Ms. Nilofer Akbar, for the respondent paragraph. While the prayer in the present, while the prayer in the main public interest petition is to direct the respondent governmental authorities to take over the possession of the entire Gomal land in survey number 81, at measuring 54 acres and 38 guntas at Vittasandra
Vittasandra.
village, Begur Hobli, Bengaluru South Taluk, and also to preserve the said land for public purpose, comma, the applicant herein by filing the present interim application seeks to implead himself as party respondent in the proceedings. Post of the case of the applicant paragraph is that out of the subject matter land, comma, the government of Karnataka had granted part of the land in the said survey number under the land grant rules 1968. It is stated that the grant was made in the year 1979. And the grant chit, public cultivation certificate, came to be issued to the grantee. The certificate is produced along with the application. In the aforesaid view, it could not be said that the applicant is not an interested party in the proceedings. Any order which may be passed in the public interest litigation may affect the applicant. Therefore, the applicant is the interested party to become proper party to be implemented. Accordingly, paragraph. The interim is granted, the applicant shall be permitted to be on record as party respond number
10.
10.
10 to 15.
10 to 15.
10 to 15.
10 to 15.
Available. Any,
Post title shall be accordingly amended.
any, in the next month, any date may be, because it's a purely vexatious and a private interest.
You are
No,
you,
I leave it to my lords.
to
I
enjoy
leave it
your
to-
possession.
I leave it to my lords. I leave it to my lords. I leave it.
Lord, my lord has posted it to afterwards.
It will come by. You want time date in the main proceeding?
My lord, I just want to verify because we filed statement and additional statements and now with the impleading applicants being impleaded, if my lord could give me a date.
We'll
my
keep it
lord,
on 24th April.
20th April.
24th April.
Obliged.
Seal number 9.
My lords, I appear for the
So the
respondent number two.
PIL,
BB.
my lords, filed by the High Court Legal Aid Services Committee. But the filing of affidavit in the format may be kindly dispensed with because it's an institution, my lords, which represents the.
But photographs are produced that the parks are maintained. Several photographs are produced.
No, my lords,
Long back.
my lords, the prayer was amended petition was filed.
What
The
is the
prayers
amended-
which are amended.
What is the amended prayer?
My lords, your lords may kindly turn to the amended petition.
My lords, I appear for
But
the
the-
respondent number two, BPMP.
Number
On
two.
In
Who
page
is-
14, I have
My lord,
filed this
Mr.
amended
N.K. Ramesh has given his NOC wakalat.
Who is number two?
6th of July 2021.
BBMP.
Yes, my
TBM.
lords.
So prayer is against you.
My lords, I appear for respondent number.
Prayer is against you.
Yes, my lords.
You,
I
are you
don't
the
have
answering
papers.
respondent?
Answering respondent. You are
No,
the
my lords.
answering. You are the answering respondent.
Yes, my lords.
So
Respondent
what you
number
have
two.
to say? You file counter.
Yes, my lords, but he has given his NOC wakalat. I'll be needing 3 weeks time to read through the papers, my lords.
Letter is of which year? 2020.
No, my lords. We don't have papers.
No paper, no wakalatnama.
No, he has given his NOC wakalat. I'll be collecting the papers. So 3 weeks time may be given.
But one of the item where the report was called for, my lords, a club is built on the park. And my lords, this honorable court directed the inspection of the property and report is submitted.
So earlier Arun Shyam was appearing. He has filed memo of retirement.
So simply you have to make a statement
Yes.
whether you are going to maintain the public spaces, the parks, playgrounds, etc. in terms of that act of 1985. As simple as that. Where is the argument?
I will take instructions, my lords. Date may be fixed, my lords.
Date will be given, but short date will be.
Very short.
And without filing counter, you are producing photographs.
Should file the counter actually.
But those photographs pertain to a park in Sheshadripuram, Bangalore, where a park was encroached and a BBMP builds a clubhouse.
If you are liking the photographs, then you can withdraw the.
No, my lords, I am saying is in violation of the act, the structure is built up and a false affidavit is filed.
Pictorial compliance is there.
Pictorial.
All right. What is your name? Learned advocate, Ms. So and so appears on behalf of the respondent to Brihad Bangalore Nagarpalika to submit that he may be granted time to file wakalatnama.
Yes, my lords.
In special 10 days time is granted. The petition may be listed on next, maybe been listed next on 15th April. 15th April.
Yes, my lords. Grateful, man.
As my brother said, this is the only thing. You come with the wakalatnama as well as the instructions, both.
All the municipal corporations are party. I also appear for one of the municipal corporations.
But initially it was for a particular park. Upon the Honorable Chief Justice orders, the matter was sent to the High Court Legal Aid Services to file a PAL. The matter was heard, it was,
To be specific.
then it was enlarged to the entire state. That is how the respondents were implicated. Lords, may I make one more request, Your Lordship?
There is only statutory amendment.
Lords, may I make one more request, Your Lordships? Not the filing of affidavit may be dispensed with because it is by the High Court Legal Aid Services Committee. It is not in an individual capacity. So I cannot file an
High
affidavit.
This petition is by High Court Legal Service
Yes,
Committee.
yes, upon the order of Honorable Chief Justice. Sorry.
This petition was confined to Bangalore. And we looked into the letter. Extended to all of the state. Therefore, this order was made. Expensive.
Filing of affidavit. The requirement to file the affidavit is dispensed with.
Great.
Number 10,
Let's say appear for the
Narayan
respondent
Swami
minutes.
KV.
The issue pertains to the appointment minutes. Minutes, Union of India has made a statement before the Honorable Supreme Court that the appointment minutes will be done before 30th of June. And 30th of June minutes.
This year.
This year. And the Supreme Court minutes has.
Old matter.
3.5 years, my lord, so the tribunal is vacant.
6 week time was granted to complete the process.
These minutes. The Honorable Supreme Court minutes based on the submission of the Union minutes has.
They have approached the Honorable Supreme Court, challenging the orders of my lords, imposing 10 lakhs rupees cost, either you fill the post or impose 10 lakhs cost. That order they have challenged before the Supreme Court. But unfortunately,
Page 3 minutes of the memo.
but unfortunately,
Paragraph
notice
2
has not been ordered on the petitioner minutes.
Paragraph number 2 minutes setting page 3.
By June 30th, 3 years, 6 months, my lords.
So it doesn't survive.
That's true, my lords. But 3 years, 6 months, the post is
All
vacant,
that
my
was known to the apex court.
That's 2 minutes. That's 2 minutes.
The prayer in this writ petition was to direct the respondents to take steps to fill up the vacant post of the presiding officer to the Central Government Industrial Tribunal cum Labor Court at Bangalore. During the pendency of the proceedings, this court appears to have passed orders dated 25th October 2023 and 6th December 2023. Most of the orders were carried before the Supreme Court in special leave to appeal into bracket C number 5094/5095 of 2024, which resulted into order of the apex court dated 26 to 24 in paragraph. The order reads as under. Quote the entire order. Any of the aforesaid order, nothing further survives in the present proceedings. Accordingly, they are disposed. This is the order. Entire order to be quoted.
Only our language. So it started last year. Exclusive jurisdiction. Yes. You have to advise your client to do these things. How many years the laborer should wait for you?
Minutes, the appointment in this case, my lords, was done.
There should be a limit to people before the working class revolt on the street. Do something.
Please.
Nothing.
Is number 11?
Lord, the connected appeals, Lord, first 2 or 3 appeals. If not, they're directed to serve a copy on us. Lord, then Lord, matter can be taken up because they have not served a copy of appeal on us.
11.4. 11.4, 1110 of 22, the comprehensive writ appeal filed by
the beneficiary my lords,
Beneficiary.
of the acquisition proceedings. Acquisition proceedings has been upheld by directing that the compensation has to be paid under the new act. To the extent, my lords, that there is a direction regarding the compensation, the subject matter of challenge in the writ appeals filed by the KADB as well as the beneficiary of landowners, my lords, have challenged the upholding of the acquisition proceedings by the learned single judge, with which we are now before the honorable court. Lords, in the writ appeals filed by the landowners, my lords, there is a delay.
So also. The landowner is in appeal. Challenge.
My lord, whether the Act 20 of 2022, so far as the KDB Act, whether it is retrospective or prospective, my lord. The learned Singha judge is interpreted that it will be from 1/1/2014. And based on that, since no award has been passed as on the date when 2013 Act came into effect, that is 1/1/2014, the learned Singha judge, following the earlier judgment, held that the award should be passed under the new Act. So far as owner's prayer is concerned, if the award is not passed within 1 year, the section 25, the entire acquisition would lapse. So recently in Maharashtra's case, this has been interpreted wherever 24 1A proceedings are transferred, deemed to have been transferred under section 24 1A, all provisions relating to the provisions of the acquisition and 213 Act, all proceedings relating includes passing of an award. That's the judgment. So which your lordship has to consider.
I may be permitted to serve copies to respective advocates. The Advocate General is appearing today, is not in
When
station.
the appeals are pending, they started overnight demolition. On 25th, my lord,
We are enjoying them.
we made a mention after hearing the board.
Did you have entry order in the court below?
Here
Yes,
now it
yes,
is granted, my lord.
Now here
Now
also.
interim order has been granted, my lord. They have demolished, my lord, half our houses. Forcibly, my lord, in the morning they have
There
come.
was no
Well, at 10:30, the matter was mentioned by before the court. There is a direction to communicate through the police of this Honorable High Court. And then there is a call to my learned friend. My learned friend appeared at 11:45. In spite of the oral direction, the demolition continued.
The single judges of this court held, if award is not passed to anyone.
Pleadings are over.
No, they have to serve copies.
Yes, no, the
Lord, sir.
Advocate General is appearing, not in station.
11.1, I would take notice, my lord.
But I will last
So far as
the
respondent-
respective counsel so that we can serve
Lords,
inter-side.
Yes.
Now, as things stands, all the parties are before your lordships, my lords, that, but in the inter se amongst the writ appeals, we are not yet represented specifically. But all of us are now before your lordships, in different writ appeals though.
Whoever
So we will
appeared before
intersect,
single
we will
judge,
intersect, change the notices.
the learned
Madam appears for the government. Mr. Ravi Shankar.
Lords, I am for the beneficiary.
Landowners.
No, I am for the beneficiary.
Beneficiary of
Beneficiaries.
acquisition. You are also for.
Landowner.
Ah, they are all landowners.
myself and Mr.
Lords,
Manmohan.
what now transpires is, the landowners, notwithstanding the fact that the acquisition has been upheld, they have now sold the property in favor of one big builder, that is some Salarpuria, somebody like that they have filed.
So we'll fix up.
So lordships may fix up a date, my lords, so that this is a very short point, my lords, as the learned senior counsel said. This is a very short point for your lordship's consideration, most of which is covered by various judgments of this honorable court as well as the Supreme Court. Of course, the other high courts also, which we will assist your lordships with.
So far as allotee is concerned, the apex court said so far as allotee cannot be rolled into the acquisition proceeding. His allotment was annulled, cancelled, again restored.
Anyway, we are.
That is
now-
on merits of the matter.
Merits of the matter. Now we have to formally direct notice to parties wherever they are
Yes.
not represented.
That 11.
Can I also make one more request?
11.1, respondents
Heard.
4 to 13 have been
Heard
taken.
learned advocates mention names of all, take the appearances for the respective parties. Issue that crops up for consideration in this is writ appeal. The appeal is whether the provisions of Land Acquisition Act of 2013 would apply to the acquisition question, or the provisions of old act would apply. So mention the entire name of the act 2013. Having considered the controversy for some time, it appears to the court that the appeal requires finally
Please.
notice to the respondents.
Let the
Who
other.
are-
The Lordships may direct the notice to be
All
completed
are
by
the-
service on the
all are
councils
the-
representing
Yes,
the
Yes.
other parties in the.
Respective learned advocates
Lordships.
for the respondents
Please.
accept the notice.
Lordships.
Notice returnable. Returnable on which date will fix.
But there are other appeals.
All of us are before the court.
Yes,
Your
sir.
Lordships may only direct that the service may be completed on the
Appeal-
learned councils
appeal
in
is
the coordinate
admitted.
appeals.
Notice of admission of appeal is accepted by respective learned advocates. appearing in the-
Please.
The appeal shall be listed for final hearing on 18th April.
May I request? First week, if it is not otherwise inconvenient. I'm in your Lordship's hands, just making a request.
On 29th of May.
Lordships. May, my lords, will be
29th of-
after vacation.
After vacation.
Please.
Requires consideration.
My lords, I'm in your Lordship's
Lord,
hands.
there would be certain other appeals, Lord.
In the meantime, the parties shall complete the pleadings.
Lordships.
Please.
And also exchange your judgments.
We shall do that, my lords. We shall.
Part with to learned court officers. So that on that day we can say.
I understand, my lords.
Lord, the interim order may be extended, Lord.
Interim orders operating in the appeal shall.
My lords, so
continue
the
to-
interim
one
orders
more-
were granted without condoning the delay, my lords. The delay is a very innocuous delay, but it can be
But
considered,
heard,
my
my
lords, when
lord.
the matter comes up for.
They were heard and then.
Because I
the
was not
court
heard in the
passed
matter, my lords, when they moved the matter at 10:13, I was not even notified that the matter is being moved. It's not the submission which they should
See the
make.
interim order.
Morning one should not be that hot. It become hot only after 2:30.
My Lord, there would be
You are
several
not-
other
you are
appeals.
Not to raise the voice at any point. of time.
Not all parties are filed appeals and demolition take place.
Lords, the matter was
Spite
not
of
on the
direct
board.
chat,
The matter was not,
Up to
What
5
is the-
o'clock.
What is the interim order?
Lords, interim order is not to
Status quo,
demolish.
my lord.
Yes.
So we'll say till further order.
25/1/2020.
Interim order shall continue till further order.
Lordships,
Great.
may I make this request, my lords? Instead of
Section shall. continue.
Lordships, let them also note, because the statement which they have made is that they are carrying out further constructions.
Interim order shall
Let them
continue.
also be directed, they should not carry out any further constructions.
Lord,
It's their case that they are carrying
They
out
make-
further constructions. In the teeth of this
But
order, they
our
cannot go back
houses,
and.
Lord, where we were staying, Lord, were demolished, Lord, in the morning. But at least to
Interim
the
order-
extent that,
No, no.
Lord,
Interim order which was granted earlier by this court shall continue.
great.
In addition to the interim order operating, it is directed that the parties concerned shall maintain status quo.
Lordships,
That is subject matter property.
grateful, my lords.
Lord, there may be several other appeals also, Lord, arising of the same issue. But if it would be appropriate, Lord, if all matters are posted on the same day, so that, Lord, everybody would be heard in the
When
month.
other matters are coming
But I
up.
think my learned friend, Lord, Mr. Chandrasekhar would have the list of cases.
No, if the dates are fixed by judicial order, then on that day we'll fix. If
Very well,
no
I leave
dates,
it to
then
Lord.
Get it clear.
Also, but if I decide this question, then it can be it can be reprinted.
It's not there, there's the other appeal that is filed. Not
Anyway, whatever order we are going to pass in this matter will be
Please.
printed
Very
in
well.
rest of the matters.
very well, very well. Great.
Also ordered to tag this matter. Single is already passed today morning order, because coming together by mistake with the dealing with that. Now it is ordered to list this matter.
Still number 12, Mr. Vinayak ji.
Let's,
Respondent number 1, your lordship. Filed a wakalat in this matter.
serial number 12. On behalf of the state.
The demise of the learned counsel of first respondent, I filed yesterday, filed my wakalat, your lordships.
You are appearing
I am appearing on behalf of first respondent.
in the place of respondent number.
1, your lordship. T.S. Anantram. That is for the union, Tumkur Power Karmikara Sangha.
On behalf of the respondents 4 and 5 state, an application for transposition has been filed to transpose as appellant number 2 and 3, my lords.
Along with Tumkur Municipal
Tumkur
Corporation.
Municipal Corporation, because we were not parties to the original proceedings, but in the writ we were parties. Now, by virtue of the new rules, the Deputy Commissioner, my lords, is appointing authority for all Paura Karmikas. So state interest is there because it's, though one ULB is involved, it affects the entire ULBs across the state. So therefore, my lords, I'm relying upon one judgment of the Supreme Court, where in similar circumstances,
Now, the state government wants to, because completed here, now it wants to be considered as appellant along with the Tumkur Corporation. This appeal is by the corporation, the corporation. Application no.
application is filed, 1 of 24.
Application is filed by the. No, not this. We have completed.
And in similar circumstances, Supreme Court has allowed such. May I just pass on? 2004, 10 SCC, page 740. Notes para 4. There it was Allahabad Development Authority, which was the writ petitioner. Para 4 notes.
Just go through that. Just go through and get back.
You were impleted as a respondent, wide order dated?
Lords, we were respondents in the writ petition. We were arrayed as respondents in the writ petition. Before the industrial tribunal, we were not parties. They had arrayed us as respondents 4 and 5 in this appeal.
IA is there.
It is IA 1 of 24.
Supported.
So your commissioner,
Please, my lords.
Commissioner Tumkur City Corporation.
No, my lords. By the
I
state.
appear for the appellant, my lord, Tumkur City Corporation.
I appear
State
for
is
the
also
state.
aggrieved by this order. They are respondents 4 and 5 in the writ appeal.
Do you have objection for allowing transposition? You cannot have because you are also.
I have no objection.
I would like to go to the affidavit. I would have a copy of the affidavit. What they have filed.
Generally, transposition is a matter of.
We understand about that, but I should not have any objections about that.
The proceedings of writ appeal, number 151 of 23. Are by the appellant Tumkur City Corporation, in which the challenge is addressed to judgment and order dated 6th December 22, learn a single judge. The writ petition of the original petitioners, the respondents herein came to be allowed. And the judgment and order of industrial tribunal. Industrial tribunal?
Yes.
Industrial tribunal.
Page over 190.
Granting regularization benefit to the petitioners was upheld. Correct. It is in these proceedings of writ appeal that the present interim application is filed by the state government, seeking itself to transpose as co-appellant. Please full stop. The applicant state was already a party respondent.
Please.
The original proceedings. Full stop in this paragraph. In the supporting affidavit filed by the state, it stated that the case and contentions of the applicant seeking impleadment are similar to those which are raised by the appellant seeking to challenge the judgment and order of the tribunal. Full stop. The court has considered the governments made in the supporting affidavit. Full stop. In Kiran Tandon versus Allahabad Development Authority and another into Brigade 2004 10 SCC 745. The Supreme Court held that the court has power under sub-rule into Brigade 2 of Order 1 Rule 10 of the Code of Civil Procedure 1908 to transfer a defendant to the category of plaintiff. It is stated that where plaintiff agrees, such transposition should be readily made. It is further held that the power could be exercised to the High Court in appeal, if necessary, even suo motu, to do complete justice between the parties. In that case, the pleas, in the case before the Supreme Court, like the case on hand, the pleas raised by the Allahabad Development Authority and the state of UP were identical. And this Supreme Court, laying down the aforesaid principle, permitted the implement, transposition, a straight paragraph. In view of above, the present implement application deserves to be favorably considered. Full stop. The applicant state is permitted to the original respondent shall stand transposed as co-appellant in the writ appeal. The cost title shall be amended.
Please amend. For formality, a separate case number may be, writ appeal number may be assigned.
Why?
Not necessary, my lord, because both of us can argue, my lord, in the very same appeal.
Why separate number? Suppose in a suit, transposition happens. Another suit number will be given. We have adopted EC-wide Rule 37 of writ proceeding rules. Whatever applies there applies here also.
Very well.
Both the appellants shall have right to raise their respective one. Yes.
Grateful. Can a date be fixed, your lordships? Can a date be fixed, your lordships? Can a date be given, your lordships?
Date.
Yes,
Interim order may kindly be extended.
Now reopen. 3rd June. Please, grateful.
Can it be a little bit earlier, your lordship, because it's a question of Karnataka?
This can wait.
Interim order may kindly be extended, madam.
Interim leave is granted.
Please.
Interim order granted earlier shall continue to operate till the next.
Much obliged.
Grateful.
December 13.
Lord, I prefer the respondent in the contempt petition and for appellant in the writ appeal. Lord, I need 1 week time to file my reply.
Your lordship may kindly see, my lord. Your order under contempt, my lord, annexure F, my lord. This honorable court, relying upon a judgment of the honorable Supreme Court, saying that, my lord, the juniors of the complainants are already regularized their service. These complainants are working from 1986, my lord, and their services are not complete.
Appeal is there.
At the request of learned advocate, Sir Prakash Timanna Heber, for the respondent, stand over to 26th April.
The complainants are about to retire in April.
Lord, they are not entitled, my lord, because they continued in service on the basis of an interim order.
April.
The Umadevi's case.
April. The first complainant is retiring in April, and the second complainant in May, my lord.
16th April. 16th April.
14. Prakash.
But I represent applying. The last date, the Sample Court passed an order on 1/2/2024. Permitting me to take hand summons and to serve the copy of the summons to the respondent. I served it. Acknowledgement also I filed it before the registry. It is put up. Now it is, so far as respondent 3 is concerned, notice is duly served.
Financial corporation is not appearing. You are appearing
I appear for respondent number 1 and 2, my lord.
for corporation.
Corporation, please, my lord.
Corporation is served. Now respondent 3 is action purchaser. He claims to be action purchaser. Now here is a case where KSFC lended loan for an industry and I am only the surety guarantor, a small dwelling house of 30 into 40. My lord, now the entire amount has been also paid and discharged with the KSFC. KSFC officials, they have misused it and even the concerned officer also dismissed later. Well, that's the one point. Second point is,
Auction proceedings are over.
yes, yes.
Title must have passed.
Second point is,
Title must have passed. Title of the property pursuant to completion of auction.
to my information, it is not passed.
Why? How?
Well, because as on that day, when they have auctioned this property, the entire amount has been paid and discharged. That's the endorsement they have given at annexure F, page number 66.
So you paid the entire amount.
I have paid entire amount. That was the endorsement and acknowledgement made by the corporation at page number 66, annexure F. That's one point.
But that happened in April 2011, auction took place.
Action
Took place in
19th
2006.
April 2011.
11, but they have not executed sale deed by that time. They have not executed sale deed because of this. When we negotiated one-time settlement, we settled the entire due amount on at annexure F is the acknowledgement they have given. That is totally
On submission.
66, my lord, page number.
Submission, there is a delay of 176 days.
The above loan account has been closed in our books with payment of rupees 4,78,928 received on 21/1/2008 by way of Government of Karnataka interest subsidy under one-time settlement. The agency loan account is still continued void so and so. This is the total amount we paid it. Then, in the meanwhile, on this point of guarantor, the Humble Apex Court also declared law. That's in Narsimaya versus KSFC Karnataka State. That decision also I have cited, it is at page number 77 at annexure H. Not against a guarantor. It's only by invoking section 29 of KSFC Act. It's only under section 31 mortgage. By filing a civil suit, they have to recover the possession in case if they are due. There's the law laid down and settled before the Humble Apex Court in Narsimaya versus State of Karnataka. In spite of that thing, now the authorities.
You are borrower or surety?
I'm surety, my lord.
You are surety.
I'm
What's
surety
your-
only, a small dwelling house of 30 into 40, where even now I am living.
All these things happened in 2011. How all that can be? That's the learned single judge says at this length of time, nothing can be done. So consistent with
My lord,
The petitioner is the mother of the borrower, my lord.
mother of the borrower. And she became the surety.
And she has
a
executed the
small
guarantee.
scale industry where.
Under section 29.
Please, my lord.
Section 29, small scale industry which the another person has established, for which my dwelling house has been offered as a guarantor and later.
That division bench with Justice K.L. Manjunath.
That's the Narsimaya also. State of
Which is-
Karnataka.
that is Narsimaya.
May kindly pass on that.
They say 20 missed the borrower. This was not appealed to, this is the law as in today.
Before the Humble Apex Court, it has been upheld. That's what the page number 77 at annexure H, the decision, the law laid down by the Humble Apex Court, I have an XML. This is in the year 2008, 5 SCC, page number is 176. In my writ appeal, I have annexed at page number 77. Then the lordship SB Sinha and LS Pant. in my paper book, page number 77, my lord.
Sale deed is also executed.
Sale deed is also executed.
Sale deed is also executed.
That was executed
2006.
21 January 2006
Six.
itself. All of a sudden, you have woken up and come before went before the learned single judge.
My lord, when we are negotiating for this one-time settlement and there was a clearance from
After
the,
sale deed was executed.
my lord, the officials know it very well. Officials know it very well. And we have also made a representation. This is one-time settlement. And the concerned deputy manager of the KSFC about this incident and other incidents, she has also been dismissed from
Third
service.
respondent is the auction buyer.
Please,
So sale confirmation certificate, sale deed, everything is complete. The whole thing is complete.
At this length of time.
And it was complete when you approached the court.
My lord, proceedings are right from 2007 onwards. We made a representation, there was negotiation. And even by accepting this amount of 4,87,000 at annexure F, page number 66, my lord.
Go before the civil court, if you get at all, you can go.
We'll reserve liberty to you to a judge because these are all
But in fact-
29 proceedings.
Kindly, my lord.
And they have their own constraints, even by going by Narasimhaya judgment. Okay, number one. Number two, you have an alternate remedy. Go before the court and whatever period you have spent here, maybe you may be entitled to, which is section 14 of limitation act, whichever.
in fact, they have approached the civil court.
Civil court also.
My lordship, in fact,
Civ-
OS has
civil
been
ca-
dismissed. RA, they have preferred RA also is dismissed.
They have
my lordship.
gone.
And
No, civil case earlier, is the earliest
year
part of time,
2006 only they have approached
bare
the
injunction suit, they have filed before the Honorable civil judge court in Kolar. It's only for bare injunction, that has ended. And even in RSA,
Dismissed.
my lord,
That number you have stated.
Yes, my lordship.
RFA number, the RA number.
Lordship,
RFA
in the
number.
judgment, it has been extracted.
I
my
myself
lordship.
have stated, my lord.
Extracted.
I myself have stated.
It is there, number,
But please, in the page number 15 of the appeal memo, my
page
lordship.
number 50.
15. In the last three line, my lordship.
Yes.
The petitioner has filed original suit number 6 of 2006 against the
6
respondent.
of 2006.
Please, my lordship.
By the same Krishnamacharya. Ah. So reasons to follow dismissed.
Great.
There is nothing.
With some observation, so that because they are poor persons of a small dwelling house, my lord. It's
We
a-
can
so
keep
that-
all content, we cannot say that the suit to be filed by you should be decreed.
No, that's only
We'll
a
say
suit.
all contentions, if you can take, you will be able to take, but we are not sure because the res judicata comes, your suit is rejected, your appeal is rejected, where is the question of reserving liberty now? What for? To
no.
litigate again?
No, my lord, that's a suit for bare injunction. That has reached finality. Now,
We are not going to say that this dismissal will not come in your way. If it comes in your way, it comes.
and the law laid down has not been properly applied is my humble submission by the,
We'll say the all contentions are open, but we are not going to say that dismissal will not influence. It was two very nice things we are making distance. Contentions are open, whatever available in law for both the sides.
please, my lord.
Grateful, my lordship.
Say number 15. Mr. P. Akaram Bhaiya.
Here for the respondent.
The order under the complaint is annexure C1, page number 26, my lord.
Yes, against the interim order, my lord, we have filed counter affidavit also.
And your lordship may kindly see annexure C1, page number 26, my lord. There is an order by this honorable court. The respondents are directed to not to dispossess the petitioner in the land in question until further orders, page number 26 and 27, my lord. That is enforced till today, my lord. In spite of that, the second respondent has passed an order that was challenged by
You seek remedy at the hands of the learned single judge, as we have already held repeatedly.
Yes, my lord. And one more submission, my lord. Another contempt petition again on the same cause of action 936 of 23. It may be posted along with that, my lord.
This we will dispose of. When that comes, we will mention this also.
But your lordship may kindly see the photographs, my lord, wherein
What photograph you have produced?
I have not.
Sorry, himself. Only
They
on
have
the
done-
ground that
Did.
the order brought under this contempt jurisdiction is an interim order, and that the parent proceedings are pending before on a single judge at large on merits. Comma, this court is not inclined to exercise its contempt jurisdiction, comma, full stop, leaving all the contentions open for both the sides to be agitated before on a single judge. Proceedings of contempt are not entertained and disposed of accordingly.
Number 16, Shyam Shiv Prakash.
I appear for the respondents accused. my lord.
Complaint, my lord.
I have filed my counter. This is
Counter
again
is served on
contempt.
me on the last Saturday because the factual incorrect statements are made.
What
I
do
mean-
you want to do? You want to argue or you want?
No,
to
I
file?
want to file my counter to that.
But this is again
Incorrect
contempt on
statements
interim
are-
order and writ petition is pending.
Order.
It's a writ petition is pending and we have filed a detailed statement of
My lord,
objections.
interim order, but the
Felling of trees.
my lord, the damage of damage is irreparable.
Similar man.
My lord, it's not, my lord, it's not similar. May I make a, now,
We have held
correct, my lord.
where interim orders are brought before us in complaint, we do not entertain unless you make an extraordinary case.
My lord,
This
I-
is how the judgment runs.
I will make extraordinary case because it's a disaster caused to the environment by this officer who is so arrogant, knowing fully, my lord, my respectful submission, knowing fully well about the interim order not to fell the trees. The trees which are in the Taluk of Srinivaspura, it's about 130,000 trees he has felled down. I have the proof, I have the satellite pictures, and now when we have shown the interim order and also the video conference made by the learned Advocate General, Additional
They are
Advocate.
the contents which can be.
These are
raised
absolutely
My lord,
baseless.
those contention I can take, but the manner in which the court orders, the law of the land, these persons are disrespecting.
Even that you can take up before the
Like,
learned
we
single
can take,
judge.
but vigor before this sample court is altogether different vigor for the orders in the contempt, because I am so appealing to my lord. Of course, in a lenient way, it can be taken, but here is an officer who got most disrespect to the court orders and the law of the land.
Absolutely
That has to be inquired only by the sample court, and it is,
They are felling trees.
they felled about 130,000 trees of 30, 40, 45 years old. They claim, it's not on merit, they
These are
claim that.
absolutely false figures which are being.
My lord,
put forth.
I have
There's no
the-
basis, my lord.
I have the satellite
They-
pictures.
They
I
are
have
all
the
forest
satellite
encroachers.
taken.
They are all
Taken.
forest.
Yes.
It's also not only, not a violation, it's a crime on the society and
But
on the
that's not-
environment.
One second.
My lord,
Our process, judicial process, regardless of our individual feelings, has to be normative. If we have taken a view that wherever complaint is against the violation of interim order, then the same should be carried to the judge who has passed it. No, because you are saying it, what all you are saying
Please,
may be
madam.
true also. We will not say true, false, etc. because he is disputing. We cannot change the pattern of our process. Because the credibility of the institution, you will again, if somebody will ask other day, you entertain complaint of Shiv Prakash and why not mine? Please, therefore, all contentions will keep open, find out.
my
remedy also.
my
Have already-
appeal to before my lord is, of course, what my lord has taken decision, I don't come in the way. That's the view.
It's affirmed by
But-
the Supreme
but-
Court now.
But the vigor of this court's order, when they have blatantly violated, that has to be.
They
looked-
should be punished,
That has
but
to be
not by us.
looked into in a serious manner, because these officers, these bureaucrats, they have their own thing in their mind. They dance to the whims of local politicians or such, but they should respect to the court orders. Here is the instance. No,
No, my
it's
lord.
no.
Nearly
It's
not
a-
PA.
Here is a case where it is a classic case, I can demonstrate the manner in which this has been blatantly violated and disrespected. That's my concern. And second point, which I would like to make my respectful submission is not only violation of court order, It's not only violation of quota, it's a crime committed against the environment and the nature. Of course, the merits my learned friends say, I can dispute it and I can also demonstrate. It's a, what's a forest land, what is a Goma land, what is a granted
But
land.
learned Advocate Mr. Shiv Prakash.
Please, my lord.
For the complainant and learned senior advocate Mr.
Additional advocate.
Learned additional advocate general Mr.
Kiran Ron.
Kiran
Ron, R-O-N.
Ron. For the respondent assisted by learned so and so.
AGA.
For the respondent.
Mohammed Javasha.
Full stop. It is order dated
28/8/1923.
We are aware.
Please, my lord, please.
28th August 23. As by a single judge in the proceedings of writ petition number 19171 of 23, which is brought under the contempt jurisdiction. Full stop. Admittedly, it is an interim order whereby the respondents are directed that there should be no felling of trees in the land bearing survey number 34, Mallampalli, Neva Vanki Hobli, Srinivasapuram, Pura, Taluk, Kolar district. Full stop. It is tried principle that interim orders, against interim orders, the contempt jurisdiction is normally not required to be exercised unless an exceptional case is made out or that the order brought under contempt has the trappings of finality. Full stop. The present case does not have any such exceptional element, nor has the trapping of finality. In that view, the court is not inclined to entertain the contempt application. Full stop. The proceedings of writ petition are pending at large before a single judge to be tried on merits, to be open for the parties to raise all the contentions before a single judge and work out their rights and remedies. Full stop. The present contempt petition is dismissed. Contempt application dismissed only on the ground only that it is against the interim order.
Yes, only one request is
disposed of.
Disposed, because otherwise they give wide publicity.
We make it clear that the interim order.
It's the other way around. The
December 17, Mr. Subramania Bhatt.
In this matter, Lord, we have filed counter affidavit. But considering the direction is to consider their claim in the light of Annexure T. A detailed order has been passed as per Annexure R4 dated 2/2/2024.
I may be permitted to file my rejoinder. It is not complied with. Rather, my lord, endorsements have been issued with the same reasoning and grounds. Lord, those have been set at naught by the learned single judge.
Remitted for consideration, reconsideration.
My lord, now, my lord, please see at page 49. My lord, after having referred to the cadre and recruitment rules, my lord, the learned single judge has been very categorically, my lord, to record the finding that I do possess a qualification for the post of junior training officer. My lord, my claim was refused on the ground that, my lord, I did not possess the qualification. The learned single judge, my lord, categorically holds I do possess a qualification, and in that light, my lord, a direction was issued to the second respondent to reconsider it. Now, please see, my lord, page 49. After having extracted the relevant cadre and recruitment rules at para 7, para 8 at page 48. No, my lord, the subsequent endorsements contain the very same reasons. My lord. Now, the department representative was one of the members of the selection committee. In his presence, I was appointed.
Same reason is reprinted. No. What was the reason earlier? That he lacked the qualification.
Yes.
Now, what is the ground on which you have
as
rejected?
per the notification, we have, as per the notification dated 25/5/2019, we have clearly prescribed the qualification for this particular post, junior training officer. and he doesn't possess qualification as per C&R rules, my lord, in order to grant the salary at par with the government employee.
But that was not your contention before the learned single judge, or it was?
It was, my lord.
Then it's res judicate. If you had not taken up, constructive res judicate. If you had taken up and decided, then conventional res judicate. Reiterating what res judicated is contempt.
Let me kindly see. He was banking on 23/12/2008 notification. The qualification prescribed in the year 2008. This notification is of the year 2019. And in the notification itself, we have prescribed the qualification.
But that was not if that was your stand. If that was your stand, the court would not have allowed the writ petition at all, if that were to be accepted. Writ petition came to be allowed, faltering your reasoning. The reason which has been faltered cannot be reprinted. That's the law. Any standard book on administrative law, in different words it might have said, but this is the law. Where a state authority's action is faltered and matter is remanded for fresh consideration, it cannot print the same reasoning. Otherwise, where is that's the policy on which doctrine of res judicata is founded centuries ago. Even in Hindu philosophy, Purna Nirnaya Siddhanta in the Gautama Sutra, what is already decided cannot be reopened that way.
In fact, I have advised them to file a review also.
It is interpretation, but this is substantive rule itself, which Gautama Sutra mentions. Purna Nirnaya Siddhanta, Purva Nirnaya Siddhanta, Purva Nirnaya Siddhanta.
So you repeated the same thing here?
Same thing they have repeated.
No, my lord. This earlier, there is a difference between
Speaking
the
of
earlier.
2019 qualification.
Yes.
When the matter was decided, subsequently, you had taken up that contention. The court did not agree with that. Had it agreed, where was the occasion for remittance?
Lord, in the impugned order, Lord, this was not referred to. 2019 qualification was not referred to.
Then what? Read section 11, 76, 1976 amendment to CPC. The ground which you could have urged but failed to shall be treated as constructive res judicata. And we have adopted that under our writ proceeding rules.
Lord may grant 2 weeks time, Lord. In the meanwhile, I'll advise Lord, my clients to review, file a review or
15th April will be not beyond that. 15th April. Today we are granting more than 2. We can keep it on earlier, little earlier. Second April.
Lord may kindly have it on 15th April, Lord, so that in the meanwhile.
Try to take instruction that 2nd April. If really needed, we'll so that now this order you are producing at R1 endorsement or order. Whatever.
R4, Lord. R4 is relevant.
That authority is writing like you become a judge. Is reproduction of your order?
Reproduction of the order.
Page 18.
18.
R1.
Yes.
Good.
In your objections, in your reply
Yes,
statement.
Yes, yes. Reproduction.
Then all. Second,
Grateful. Public.
So number 18.
What's the divorced daughter of a deceased government employee, my lords, files an application seeking for appointment on compassionate grounds. that is rejected by an endorsement by the government, my lords, challenging which she goes to
Consider. You have filed the objection?
Yes, we have filed an affidavit.
Let's
So
go-
considered,
Considered and rejected.
rejected.
on the same ground, which was
ground.
set aside by this honorable court, my
But
lords.
as
Rule-
in the date of death, as in the date of death, that the divorced daughter was not included in the rules, in the definition of
The
the
same
family.
thing,
Yesterday's matter. my lord.
yesterday's matter. My lords, here, could I kindly persuade your lordships to go to page 18, my lords, where this aspect has been considered.
Beamish judgment is squarely applicable.
Madam Vaishali Hegade's matter, my lords, yesterday. I think veterinary sciences. May I request your lordships to well, it's here, there's a slight difference. Yesterday, I was there in the
We
matter.
have reserved
Here, yes, my lords, here, this honorable court,
Understand.
yes.
That point, we may treat that. Therefore,
There was one more thing which the honorable court considers, my lords, at page 18. I would not pursue it more than that, my lords. Your lordships may look into that also. The effect of substitution also, this honorable court looks into it. That's all. I was there for the whole matter yesterday, my lord, so I know the.
10th April.
10-4.
This matter, my lords, even the financial aspects was considered in that matter. Madam Vaishali submitted that they had more financial resources. Here, that is also considered. This honorable court holds, even the financial resources is very well within the limit. That is the only difference between that matter. Obligement.
Number 19, Mr. Nagaraj Jagade.
Use it. This is also not against the contempt petition is filed, is also not exist interim order granted by the
Interim order.
major violation is, my lord,
that's why I'm for the
2 acres of
appeal.
portion, my lord, there was a apartment construction is going on, my lord.
RSA.
Even after, yes, ma'am.
RSA.
Yes, ma'am.
Interim order is in RSA.
Yes, ma'am.
Take redressal there only.
Pardon me.
Redressal should be sought there only, at the hands of the bench which passed that order.
Only my concern is, my
Still
lord,
pending.
they are selling the properties.
Therefore,
by
you should
putting up
tell it to the court.
The apartment, no. The entire major portion of the apartment, no, which is under construction, even after the order of interim order, no, not to put up any construction and not to make any improvement in the scheduled property. No.
Oh, section. We call it as RSA.
These contempt proceedings arise out of interim order dated 15/3/22, passed in the pending regular second. Since the order is interim in nature, so no final rights are crystallized. The dispute between the parties is at large on merits before the court concerned. In that view, the contempt jurisdiction is not required to be exercised. Therefore, only on the said ground, the proceedings are not entertained and stands disposed of, leaving it open for the parties to approach the court where the appellate proceedings are pending to work out the rights and remedies in accordance with you.
Still number 20, K. Ravi Shankar.
Respondent.
For complaint, your lordship. Page 15 is the direction, my lord, page 15. Application, my lord, filed, my lord, in 2016, my lord. This is the second round litigation, my lord, third round litigation actually. Page 15, my lord, may kindly see para 3 of the order of the learned single judge. Having taken note of the fact that the petitioner has sought for page 15, my lord. This order has been passed in July 2023. My lord. Respondents to observe the petition in any departments under the Ministry of Commerce and Industry. And in this regard, the respondent department has addressed letter dated so and so. Next, why concerned undertakings of the said ministry, I am of the view that the
You
petitioner be
consider-
But I
permitted to
have
make
filed
one.
my affidavit and we have completed the order. Within our capacity, we have recommended the departments to absorb the petitioner as and where it is
State.
suitable.
State will take this.
No, state is not party here.
State is not a part.
Sent to
Only
the
Union of
you-
India. is
You
party.
should
recommended
Union
to
of
whom?
India. Union of India
Recommended
is
to
the
whom?
party.
Sorry.
You recommended for absorption of the petition.
Yes.
Yes, to the several boards,
To the,
several boards. Coffee board, rubber board, etc. He was earlier working in STCL and due to winding up of the company, he took VSS, voluntary separation scheme during the year 2014. And
You
thereafter,
have recommended.
thereafter also, we were repeatedly recommending and as and where they were suitable and
To
required.
whom you recommended, when?
After the
When did
passing,
you recommend?
after passing of this order
That is
on
no answer.
6/9/2023,
To whom you have recommended?
to some 29 boards we have recommended.
To whom?
To several boards, coffee board and rubber board.
In
I have
which
produced
board?
that recommendation letter also in my reply affidavit.
Now, who should absorb actually? Your recommendation you have sent now.
Yes.
On that, who will act upon?
The boards, organizations who comes under the Ministry of Commerce.
Yes.
Some employees were absorbed under in coffee board. He was not absorbed because there was an age limit. He crossed 40 years of age, therefore he was not absorbed in coffee board.
Complainant.
Yes. In the writ petition, coffee board was also party. In my reply, I have produced my recommendation. If he fulfills the requirement of the post, they will absorb. Otherwise,
No, you had recommended after seeing all these things only, or without seeing you have recommended.
after seeing all these things only.
Therefore,
yes.
decision has to be taken now. You cannot contend that he is barred. Otherwise, you would not have recommended.
The departments have to take decision.
But you have recommended
Yes.
that he should be absorbed.
Yes.
And this you did not closing eyes.
No, my lord.
Yes. So now you cannot contend that he is barred and other things. But you represent the secretary, Ministry of Commerce. He is the authority who has to take the call on your recommendation.
Yes, to recommend the departments, other boards.
Whether all boards work under this department, whether boards are superior or secretary is superior.
Secretary superior, but as per their rules, they will see whether he is competent for absorption or not.
you are not supposed to recommend, you're supposed to direct. Comply with the direct.
Because they are subordinate to you.
So you have stated in paragraph, it is not accurate. Paragraph 6. Union of India Requirement to Commerce, by letter dated 24/2/14, has circulated the details of 31 acknowledged. It's too vague, as vague as anything. To STCD Limited, including the name of the complainant, to various organizations under Department of Commerce, or commodity boards along with tobacco board, etc. With an advisory to absorb. It doesn't.
All they work under the government. They are all your bodies. They work under this ministry. Therefore, question of, as my lord has said, question of recommending will not arise. Always recommending is from the subordinate to the superior. That's how general, unless the law otherwise says.
The fact that he took a voluntary separation scheme
He took voluntary separation scheme during the year 2014 itself and received the ex gratia amount also.
But why did you recommend? Whatever, once you recommend, you cannot contend contrary to the substratum on which recommendation takes place. This is the minimum we can say. So something has to be done.
I will take further instructions and
Or what? How they have been established?
No, the
they are companies.
Ministry of Commerce, my lord, has established various boards, my lord, in respect to the various development activities, your lordship.
But they are
Like coffee board, my lord, coffee board is supporting to the coffee.
That is under the Coffee Board
Yes,
Act.
your lordship. Yes, your lordship.
There is a special statute.
Yes, your lordship.
Rest of the things where you are seeking absorption. What is the status of those boards?
They are
Unless that is
PSUs.
spoken of either by either of you.
Yes, I will, in the.
Your relief was against which?
My lord, my lord.
Your relief in the main petition was?
Yes, ma'am.
Under the coffee board.
Under the coffee board, your lordship. Coffee board,
Yes.
coffee board, my lord.
Then coffee board is a party?
A party.
Who appears?
No, in the contempt coffee board is not party. In the writ petition, coffee board was party.
Coffee board, my lord, because because the Ministry of Board, my lord, industry, my lord, has to recommend to the, this one, my lord, the
Again, you are
board.
confused.
I will make them as a party. Coffee board.
Was earlier working under STCL Limited Company.
I will make them.
Since you committed mistake, they are misdirecting themselves.
Yes, I will make.
You make a party, in
I
any
will
case,
make.
the coffee board was party in the main proceedings.
So in the main
And the
proceedings.
relief was directed against that coffee board. So unless you join the party here in the contempt proceedings, how can you seek compliance from the court? Against whom will be seeking? Learned advocate, Mr.
Sure. Shuram, my
Ravi
lord.
Shankar?
My colleague, my lord, Michael.
Shivaram.
Yes, my lord.
You are Mr. Ravi?
Shivaramu, HC, my
Shivaram.
lord, appearing for Karan.
Shivaram.
Yes, I sought
Appearing
permission, my
to
lord.
the complainant raised that he may be permitted to plead. Coffee board, what is?
Yes,
the entire
coffee
name?
board.
As part
Now
of
its
the
name
board.
is different. Coffee Board is, nomenclature is changed.
No,
Remains to be
coffee
coffee.
board remains.
It is same, my lord.
Coffee board as party respondent hearing. Since the said board was a party in the writ proceedings, but omitted to be joined in the present proceedings. The complainant shall join the coffee board as party respondent. Post title shall be amended. The register shall issue notice to the newly read party, returnable on 15th April. Full stop. It is directed that the newly read party shall respond to the grievance of non-compliance of the order.
Grateful, your lord.
Number 21 urgent, number 22, Mr. Aditya Narayan.
Here for that. 22, 23 and 24 are all appeals from the same, one common order of the learned single judge. I'm saying 22, 23, 24 are appeals from a common order of the learned single judge. The registry has noted non-service to one particular respondent in all three appeals. That respondent, your lordships, is the Bar Council of India. That party was deleted as a party by the learned single judge, was erroneously made as a party to the appeal.
Who are three?
The Bar Council of India, who is in serial number 22, the respondent number 3, In serial number 23, the respondent number 21 and respondent number 3 in 24 also.
So bar council deleted.
Maybe deleted.
Maybe or earlier deleted.
It's deleted. I'll show the impugned order. Impugned order
Deleted in
marks
the-
that part is deleted.
Deletion
In the
already.
writ itself, cost title shows, my lords, page 36 if your lordship sees.
Yes.
Page 36 of the writ appeal 1443.
So that is an objection.
The registry has noticed, it is not an objection. I have not served that party. Registry has made a note of that.
So that forget about.
Direction is to consider, reconsider the claim for regularization.
That's the substance of the appeal. It is
Much
not
liberty leverage is
regularization,
left
it
to
is-
you.
It is actually not regularization. It is continuation of a contract that
All
is.
right, it's all right. Everything is in your court. It's an open remand.
It is, Your Lordships. On the merits, I'll separately argue, Your Lordships. My request is that all three appeals may be tagged together and post, and one date may be given. I'll argue on merits on that.
Who are you?
Not ready today.
Not ready to. The senior has to my senior colleague has to submit.
You are for?
Lords, I am for the respondent, that's the petitioners before the learned single judge.
Employees.
Some
Not
of them, when the law school started, they have been working, my lord, some of them. And all these are cooks, gardeners, all class
But
B.
general council is the highest body.
Lords, EC, executive council, but they can place the,
Before general council.
that's all.
No, it doesn't.
That's what, lords, ultimately, and these are all in 45, 50s.
Want it to be placed before the executive council.
Pardon me, my lords.
They want that they should be
Go before the EC. EC will not hear, the GC, I mean, sorry, the general council will not has all the, that's also a big body which consists of
Madam,
vice
I could
chancellor,
have directed
judges.
accordingly. There is nothing wrong.
There is nothing.
It is on the contrary, the highest body which will taking the.
They will ultimately, the
go
executive
to-
council will have to take a decision.
The submission is that EC has already considered this and taken a decision, and there is a report of the EC also on this. The EC has already considered this issue and has taken a decision.
That
If I
was
may
in
be
the
given
past
one
without
minute-
even hearing us. What happens, my lord? They formed a subcommittee. There was one committee's report which said we have to take the steps to regularize these people. Another subcommittee and they're out.
Have it some other day.
Please.
Madam wants some.
I have no. lords.
May I request that these three appeals may be
Tag it
tagged
with.
together? I have one more submission by an error probably of communication from my side. The last order in writ appeal 1459 records the other two the year of filing of the other two writ appeals erroneously. So that's why they have not been tagged together and the registry has noted it in the
But identical
objection
issue.
also. It's all identical. It was listed.
Common
It was
order.
all heard together. There's a
To
common
be-
order.
This appeal shall be listed along with 23 and 24 on.
There are only
No,
three. All
there are three
all
are together.
22, 23 and 24 may be listed together. That's all.
Together
That's
on 16th April
great.
and no further time
Great.
because this is probably second time you are seeking time.
It was
As far as I
listed
know,
for the first time,
might
the
be more
last
even.
time. I will not seek time. I will argue it next time.
Oh.
Seeking deletion. That memo is, that was deleted there only.
It was
There
deleted
on-
there only.
no.
I have
Question
not
does
filed a
not-
separate.
question does not-
I have not filed a separate.
Still number 25, Mr. Srinivas V.
Need to file my objections, my lord. weeks time may be granted.
May I seek for a date will be fixed.
17th April.
Number 26, Mr. Shyam, ye
This
Nimikal.
matter, we have filed complaints of it.
For the complaint.
Direction is to consider their representation, we considered and rejected.
For the post of director.
For the post of the director,
Consider.
it's only a 3 months is
Rejected. Considered is representation rejected.
Rejected.
We
Then
issued an
file-
endorsement.
Rejected.
You have served a
Hello.
copy on them.
Yes.
they have filed an, there is a check bounce case. They have referred that one. On that basis, they are telling that it is not possible. They have not, when the order was passed in the writ petition, they have not challenged that order. And the steps are not taken. When the court had directed, within 4 weeks, they have to take the steps. At that time, they have not taken any steps. Even after the lapse of 8 weeks, when we filed this contempt, now they are coming up with the check bounce case. I want to produce this one. This is in the stage of the appeal. I will serve this copy for you.
But how to, how to undertake a critical examination of their decision in our limited jurisdiction?
No, I am not taking. They have taken that contention that it can't be, that they are not stated directly. Till today, they have not taken any steps to fill up the post permanently for the director post. The person who is sitting here as an in charge, Mr. Santosh, his seniority is the 10. As per the cadre, it is top 5 to be considered, whether it should be in the in charge or for the permanent directorship. That they have violated. And in this regard, he has been a liaison officer. I have already stated in this petition. He has been removed for his at page number 162, my lord. Kindly come to the point, son. 162 to 160.
The check bounce case, you are accused.
Accused,
Lordship,
is there?
I
I
may
will
be
come to
permitted
that.
to
Before that,
produce
I
the
will come
order
to,
also.
I will come to one, this one. The person who is sitting as the in charge director now at present, his name is Dr. Santosh. Kindly go through the 162 to 163 page. He has given an opportunity to serve as an liaison officer. He has been removed for his.
You are convicted in the check bounce case. Are you convicted in the check bounce case?
It is an appealment.
They are asking.
It
you.
is convicted. It is convicted either to pay the amount or
In
if
default,
it is paid,
undergo.
the punishment will be there.
Is
That has
it,
been challenged in the appeal now. That
Is
is in the pending.
Is it a case involving moral turp? How this case convictions are treated? Are they treated as a conviction involving moral turpitude?
My lord, till it is, unless until it is a judgment is passed in the appellant courts, we can't say that it is an attempt that he has to pay the amount or it has to be convicted.
Whether conviction is stayed
Which one, my lord?
in that appeal, criminal appeal, whether conviction, only sentence is stayed or conviction is also stayed?
No.
It is the stage in the order sheet, it is
No.
1 minute.
What is the position? Whether in that
No.
conviction and sentence both are stayed, only sentence is stayed, suspended?
Suspension of sentence will be done. That I
You
don't.
know, you say that, otherwise do not mislead us.
That they have given only the case number there. They have not filed the entire proceedings.
We are asking you, it's your appeal.
Yes,
You are not answering the question. It's a very relevant question because of
Yes,
the
madam.
apex court decision
Yes.
in in that Sidhu, Navjot Singh Sidhu versus so and so.
No, I will come.
If conviction is also stayed, then question of
He praised the
consideration
honorable
would
court to
arise.
please
That's
to
how the
stay the
apex court has said,
judgment.
which is that judgment, latest
Case
judgment.
called out, the present appeal is filed challenging conviction order passed by the learned principal civil judge and JMF Hassan in CC number 1341 of 18 dated 1/4/23. And the appellant also files an application under section 389 of 1 CRPC seeking suspension of sentence and another application under section 5 of Limitation Act seeking continuation of delay. Heard the learned counsel for the appellant Peruz IAS accompanying affairs discloses that there is a delay of 20 days in the appeal.
Your application itself, perhaps you are.
It is accepted.
Please, your application
I'm
is
coming.
itself is, you have to be sorry because you are not hearing us. Your application itself is for suspension of sentence, not conviction.
Both is this one.
Eh?
Both it is there.
Conviction and sentence.
Yes, ma'am.
Read it, but you read only one.
Yes, ma'am. It's only for suspension.
Therefore, without saying, by your argument, we can make out what is
Yes,
what
ma'am. I agree.
and what ground probably you would have taken also.
My lord, beyond this one, the person who is sitting here is.
You have
in-
no case because of the Supreme Court decision. Instead, you challenge that. We may not say that. You have no case because of the judgment of the apex court. Apex court said, I don't remember the 2023 judgment, which says where an employee is convicted for an offense, for which punishment fine could have been more than 2,000 rupees. Then such cases to be treated as cases involving moral turpitude. Number one. Number two, where only sentence is suspended and conviction is not, you are not entitled to be considered for promotion. Instead of we writing that, you may consider, we will.
If the, I will come another point also. The person who is sitting here.
You have said, brother, this is contempt jurisdiction.
Yes, my lord.
We
I
have
agree.
our own limitations. We cannot go on arguing like this. The other many people will be sitting
No,
in the
I am not
court hall.
taking that. The person who is sitting is having them in the murder case, he is on bail.
That is no ground. It's like saying there is another dacoit who has been left out, therefore
No,
thief
no.
should not. Question is, law is very simple.
I will agree for this one. I will take up the steps and this one. Kindly allow for 15 days time, I will take that. No, I will seek the direction that whatever it is there in application where that is pending. At least 2 weeks time is required.
In the writ proceedings, the grievance of the petitioner was that since he was a senior most professor, he was entitled to be posted as director on the basis of seniority. The writ petition resulted into order dated 28 December 23, whereby learned single judge, while disposing of the petition, directed respondent 1 to consider the representation of the petitioner for the post of director on the ground, stating that as per the claim of the petitioner, he was the senior most in the cadre. It was directed if the petitioner is found eligible otherwise, necessary order shall be passed within stipulated time. Full stop. The present contempt proceedings. In the present contempt proceedings, the complainant or original petitioner has raised grievance about the non-compliance of the state directions of learned single judge. Pursuant to notice.
My lord, whether I can submit, if the judgment passed and conviction is not there, then whether it can be.
It will be readily succeed there, but not here.
There, liberty to be given.
We are not there to. We can't continue with the proceeding. Very limited scope.
At least a liberty can be given that.
That will resolve.
If the judgment is passed and the conviction is not there, then to consider this
Also the notice, the
as a
compliance-
directorship, as per the seniority.
Affidavit
At least that has to be taken.
by the principal secretary to the government department of medical education, government of Karnataka. Just drawing attention of the court to the said affidavit from a learned government leader, government advocate, Mr. S.S. Mahendra.
endorsement dated 4/3.
That where gone that?
Next year, R1, page number 6.
So somebody also taken over. Person.
Yes.
Yes.
Not person, Santosh. He says. The compliance affidavit inter alia mentions ever says under. Then page 7, the paragraph is indicated as per the institute's bylaw. Starting from that, in charge and order. Paragraph. It was further pointed out on the basis of the further amendments made in the compliance affidavit that the present complainant, thus the petitioner, faced the proceedings of criminal case and came to be convicted under section 255(2) of the CRPC for the offence punishable under section 138 of the Negotiable Instrument Act. The fine was imposed and the punishment in lieu, punishment was directed to undergo the simple imprisonment for a period of, sentence was ordered to undergo the simple imprisonment for 6 months in default of payment of fine. Paragraph. The petitioner complainant was intimated with all the aforesaid reasons that he was not considered for in charge director, not considered for the post of the director. Since the decision is taken by the respondent government pursuant to the directions of learned single judge, nothing further remains to be gone into in this contempt jurisdiction. So if it is the contempt jurisdiction, contempt proceedings are closed, it is observed and clarified that if the complainant is dissatisfied with the non-consideration from the post, it is open for the complainant to institute independent proceedings to challenge the decision. In respect of it, this court does not express any opinion on the merits.
Lord, one more suggestion. The person who is sitting here as an in charge is having a criminal case and he cannot be continued in that post. That also we are challenged. It is a murder case. That also I will give this one.
Is he convicted?
Huh?
Convicted?
No, it is the case is going on and he is on the bail.
You are convicted.
And raise that ground in your
Yes,
one more ground.
God bless.
So number 27, Shikara PK.
Lord, I'm the one.
English translations you have not filed.
But our apologies, our apologies.
Highly.
Whatever, volume 4 or 3, you'll have to file the English translation. One copy.
Okay.
Lord, I'm the owner of a land measuring about 7 acres, which is a garden land. I have put up, my lord, fruit bearing trees. Admittedly, my lord, number of fruit bearing trees are there. BDM, my lord, sought to acquire the land. They issued, my lord, preliminary notification, final notification. Ultimately, an award came to be passed on 10/11. I challenged, my lord, the acquisition on the ground that, my lord, this land could not have been acquired. Ultimately, my lord, I had the benefit of an interim order. My lord, in 2003, my lord, the interim order was granted on 19/12/2003. Till, my lord, the disposal of the suit, my lord, the writ petition, I had the benefit. Ultimately, my lord, the writ petition came to be disposed of with the direction that, my lord, if there are garden lands, my lord, this land should be deleted. And, my lord, I must give a representation.
Junjamma.
Yes. Then, my lord, 236, my lord, your lords get that. This is, my lord, Shamanna, following the Junjamma and all that. Please come to, my lord, page 236. At, my lord, first volume only. In the first volume, my lord, page 385. (384), your lords get that, my lord. Sorry. B1. 384. All the petitioners, but 384 B1, all the petitioners who are landowners, converted site owners, or non-agricultural lands.
Seeking dropping of the.
Yes, ma'am. As far as the respective lands, as on the ground, my lord, that their lands are situated in green belt, they are converted. D, my lord, C is converted. D, garden and recognized nursery lands, etc., are entitled, my lord, seek exemption, my lord, file an application, and, my lord, seek, my lord, deletion. Next page, if your lords come to, my lord, C. Till the aforesaid, next page, my lord, C, last paragraph of page 385. Till the aforesaid exercise is undertaken by the authority on the application filed by the petitioners, either for allotment of site or denotifying or exemption sought for are considered, their possession shall not be disturbed. Sorry, my apologies. 385, last paragraph, C. Till the aforesaid exercise is undertaken by the authority on the applications filed by the petitioners, that is, my lord, for deletion on various grounds, including that is a garden land. They will be, my lord, the
possession will be protected.
Yes. Please come to, my lord. That, my lord, this is full of, my lord, fruit-bearing trees is evident from, my lord, page 176, the award itself. Please come to, my lord, page 176. (176), my lord, is one award. There are two awards. Malkeys, my lord, 16, serial number 16. Valuation of Malkeys, coconut trees 85, 15 years. Arecanut trees 120, tamarind tree 1, teakwood tree, coffee trees, banyan tree, paneer tree, jungalow trees, silver oak trees, nilgiri trees.
So, standing trees.
Yes, ma'am. Then 188. It's, my lord, the abutting land. Malkeys, my lord, again, 195 coconut trees and 71. That was 70, this 71. My lord,
Page
188, my lord. 188.
It is part of award.
Yes, my lord. There are two awards. Yes. The first one which I showed was the first award, my lord, in this was 70. This is 71, my lord, abutting land. They are all one contiguous land. I gave a representation. Ultimately, my lord, the BDM, my lord, deleted the land, saying that, my lord, this is forest land. Please come to, my lord, page 431, volume 2, my lord. My apologies, my lord. Too many papers have been filed. (430) is a Kannada translation. Sorry, a Kannada version.
Who is the authority to delete?
My lord, after they, my lord, this honorable court directed, my lord, they should delete it. Ultimately, my lord, the government will have to issue a notification.
So the BDA has a recommendatory role.
Correct.
What decision was taken by the government?
Government, nothing happened. What happened was, they, my lord, said, my lord, they deleted in favor of the forest department. My lord, page 430, your lords will get that.
English translation. 430.
But 431, my lord, is the English translation, my lord.
Deletion is on the ground that it is a forest land.
Lord, my submission to your lordship says, I am the owner of the land, my lord. Kata stands in my name. The notification, preliminary and final notification in my name. Award in my name. Then they, my lord, they say it is deleted. At any rate, my lord, what happened was, there is also, my lord, page 472, if your lords has come, there's a denotification committee, my lord, constituted by the government. That also said this should be deleted. Please come to, my lord, page 472. My lord, Kannada version is at 440. English is at 472. $475 if your lords has come to, my lord. Serial number 12, my lord, at 475. Survey number 70 and 71 of Turahalli. So 475. 70, serial number 12, 70 and 71 is the land in question. They refer to, my lord, the orders of this honorable court. And ultimately, my lord, recommend that, my lord, this should be dropped from acquisition.
It dropped acquisition.
No, what happened is, government must pass orders, my lord, in furtherance of these two. One is the BDA.
Recommendation of the committee.
Committee, my lord. Committee, by my lord, constituted by the government itself. Ultimately, my lord, what happened was, BDA, my lord, somebody came to my site saying, my lord, property saying that, my lord, I have been allotted one site. So, my lord, we filed a suit. Suit got decreed, my lord, in our favor. And, my lord, having regard to this, my lord, since, my lord, they did not pass any order, we filed a writ petition before this honorable court.
On the committee recommendation, no order was passed.
No, my lord.
This recommendation is of 2008.
Yes, my lord. We came before your lordship, my lord. We, my lord, waited. Ultimately, my lord, we filed another writ petition before your lordships. In the writ petition, my lord, I had the benefit of, my lord, the interim order. And ultimately, my lord, the writ petition has come to be dismissed. Please come to, my lord, volume 1.
Writ petition was with what prayer?
That, my lord, I shall not be dispossessed.
You shall not be dispossessed.
Because I had the benefit of, my lord, an order by the learned single judge in the initially, my lord, in my first writ petition. While disposing of the writ petition, his lordship, my lord, said, the division bench said, I am entitled, my lord, the interim order till, my lord, my application is considered. My application is considered, they said they are deleting it. But my final order, my lord, by the, my lord, the final gazetted notification was not passed. Ultimately, I filed a writ petition.
You did not seek any direction to the government to consider the report of the committee.
My lord, I came before this honorable court and filed a writ. Gazette notification, my lord, I asked them, my lord, that one of the prayer is that gazette notification be issued by the government. Made the government also a party.
Government had passed the order.
Yes. Page 96, my lords, get the prayer.
96 of
volume 1, volume 1. 95 at 96. My lord, wherefore, main prayer. That, my lord, the acquisition has lapsed. Alternatively, my lord, sorry. Volume 1, my lord.
No, you had challenged acquisition itself.
No, first, my lord, if your lordship sees, that my lord, the
7/11/2002.
correct. Correct, correct.
It is anterior to the recommendation of the committee.
Correct, my lord. No, no, I have challenged that. And that was the order, my lord, which I pointed out to your lordship, my lord, of Justice Mohan Chantan Gowda at page 236.
No, we are asking.
Oh, sorry, sorry.
After the denotification committee came to be constituted in every state
Yes,
because of the judgment of apex court.
Yes.
After it recommended dropping of the lands from acquisition, what happened next?
Nothing, my lord, happened. We were waiting, my lord, for the government to pass the gazette notification. They did not do it. Ultimately, my lord, we came before your lordships. What happened was, in the meanwhile, my lord, somebody came and said, I have now been allotted a site here. So, my lord, we filed a suit. A civil suit was filed. I have produced that. It came to be decreed in our favor. My lord, that sale deed was held to be null and void. And, my lord, therefore, my lord, we came before your lordships. Filed this writ. In the writ petition, my lord, we had the benefit of an interim order. Ultimately, the writ petition has been dismissed on the ground that, my lord, there has been allotment made by the BDA itself. BDA says, my lord, this land, my lord, we are deleting. And, my lord, how can they?
Well, acquisition was completed.
That's what, my lord, the learned single judge says. Why? Because according to them.
No, but in your prayer, please see your prayer in the WP.
Yes, my lord.
In your prayer also,
yes, my lord.
You have mentioned the acquisition notifications.
Correct. My lord, if your lordships look at, my lord, A, declare that the scheme
has lapsed.
Has lapsed. Alternatively, my lord, I am also asking for quashing. Consequently issue. That is, my lord, as a consequence of lapsing, quash this.
Why it will lapse?
Because, my lord, they have not taken possession, my lord, for a...
Because you have taken order of the court, not to protecting your possession. How can that be read?
My lord, if they have recommended for deletion, BDA recommended for deletion, denotification committee, my lord, said delete the lands. Therefore, my lord, my submission to your lordship is, my lord, they can't say that, my lord, they have taken possession and farm layout. Scheme implementation, my lord, within 5 years, if it does not, section 27 of the...
No, that is only where the work is not halted by judicial intervention.
Correct, correct. I agree. That is, my lord, when, if there is a stay, then, my lord, there's a cloud on there. But what I am submitting before
that period is excluded, like section 11A.
Correct.
Land Acquisition Act. That's how the judgment came. That's the ground on which section 24 judgment was reviewed.
Correct.
By the bench.
Correct.
If that period is excluded, whether it fits into the prescribed period of 5 years?
5 years may not, my lord, because I had the benefit of, my lord, continuously from the very beginning till the end.
Then that it cannot be.
That, my lord, that is why,
will
my lord,
not lapse.
that is why I have sought for again, my lord, quashing. Because my first prayer, when I made, this honorable court said, consider, my lord, if it's a garden land, delete it. So that, my lord, in furtherance of the directions issued by your lordship's court on an earlier occasion, I have come before your lordships. That petition came to be dismissed. Against that, I have come before your lordships in writ appeal.
What happened to that? You appear for the government?
I appear for the BDM.
BDA. Government has to say, what happened to the denotification committee proceedings?
Can I just, before that note, just say something? The denotification committee, which my learned friend read, was actually, my lord, a denotification said on the basis that it's forest land. Not denotify for them.
Your under Honorable Justice Shantanu Saab's judgment,
my lord,
they were permitted to apply for dropping of the proceedings. These lands.
Yes, they made an application.
And till consideration takes place, their possession was protected by the order itself. Order says that way.
Yes, but possession is already taken before that.
Before that.
I'll point out.
No, I'll just take 5 minutes.
Thereafter, the BDA, your client recommended to the government that these lands be deleted from acquisition process because X ground, that lands are government forest land. So the committee was constituted. Committee held the proceedings. Committee also recommended to the government that we have some difficulty. We'll come to that another aspect. because secretary himself is the government. Secretary, the apex court said, the secretaries are limbs of the government, not agents of the government. Anyway, the committee was constituted and the committee said that lands to be dropped because they also reiterated the same ground, perhaps. They
Yes.
are private.
That is forest land and therefore it should not, before, Lord, denotification therefore was saying BDA will not have the benefit of that land because it is forest land.
Now, we are asking you, if it is a forest land, then process has to be under section 63 or some forest act. There is one process. Justice, Honorable Justice Devdas's judgment is there, affirmed by the division, perhaps affirmed by the apex court also, where your contention is that it is a forest land. Then for that separate process,
there was a challenge.
There
was a challenge by my learned friend's client to that as well. And there, my lord, a direction was issued to the forest department to conduct a survey because it's part of the Turahalli forest. My lord. It is part of the Turahalli forest which is adjoining this land.
Or land belonging to the forest department. Particular land, forest land. Then there is a separate machinery which involves participation in federal payment source. Now, it's in fact not because it is only recommendation for cropping on the ground that forest lands. Recommendation by the BDA and by the committee headed by the chief secretary was on the ground that was not on the ground. It is a single declared. It is on some other ground. Ex-judgment. It does not fit into that judgment because that judgment proceeded on the premise that this is a private land, but falls into one of the categories which are exempted from acquisition. That is not the ground. Only it is a forest land. Who after it was treated as a, any order was passed?
Yes, an order was passed. That was challenged before this honorable court at page 556.
Order was also
yes,
passed.
They challenged it. They challenged it before this honorable court. The honorable court then directed not the conservative forest to recheck the boundaries to ensure as to what comes within forest land or not. That was done. There's another order for that. But the main plank, not before the learned single judge, was we are still in possession of the property. And therefore, we should be, therefore, not a scheme has lapsed and therefore quash the entire thing. But the learned single judge finds that even before the first petition was filed, before his lordship Justice Shantangowda's order was made, a road had been formed in this area, and this claim that actually, my lord, this property is not acquired or not taken over is an incorrect argument. And that's a finding specifically made.
What we understand, we are finding difficulty. V.C. Ramachandran on law of land acquisition and compensation. He enlists the cases. The question of acquiring, and we have held that way, referring to V.G. Ramachandran, division bench, myself and Varalesa. Question of acquisition arises if land belongs to private party, private person, though not citizen. If the land belongs to the government, the idea of acquisition is illogical. This is how we have held now. Therefore, we want to ask, if this land was a private land, why did you notify for acquisition?
We believe, my lord, that the land was private land. That is how notification went on. As a matter of fact, the preliminary and final notifications all stand in his name. Even the award note is made in his name. But later on, it transpired that it is actually forest land and belongs to the Turahalli forest, which is supposed to be adjoining a portion of this land. Then, my lord, after that determination was made, and my lord, the forest department raised a specific ground and demonstrated that it was forest land, they got a cause of action to file a writ petition challenging that part of the order, saying, please see at page 556. I think, my lord, it is volume number 2.
556.
556. This is filed against the Chief Conservator of Forests. Volume number 2, my lords. And the prayer, my lord, is at 574.
KT Grianna.
KT Grianna, the petitioner or the appellant before my lords.
Order is at 598, my lord.
First, my lord, is the challenge to the appeal.
No, restrain from taking this.
574.
So the order was passed by
respondent number 1, who is the Chief Conservator of Forests and the appellate authority.
This is the extent of the land is how much?
7 acres and all.
10 acres in all.
10 acres.
7 guntas. 10 acres, 7 guntas.
Yes. Then not the,
what happened to writ petition?
598. 598 is the order. There was a direction, Lord.
Page 603, my lord, para 7.
Arade Sab's judgment.
Yes. This issue is still pending. There is no order, my lord, passed on the appeal. And that, my lord, the government will have to answer.
The appeal was 63A appeal.
Yes.
What is that appeal which Arade Sab is speaking of at page
Before, my lord,
603?
the forest.
64A3.
64A3.
A3.
So there was already an order against that appeal was filed.
By them, yes.
What happened to that?
Matter is pending.
That matter is pending. That is pending.
Then your whole fate depends upon that order.
Then
Lord, I asked myself this question. BDA can't say, my lord, that, when having said it is to be deleted, it's a forest land. At any rate, my lord, that it is to be deleted. Can they say, now say, my lord, that, I now continuing to form sites and then, give it to them. Therefore, my lord, status quo order has to be maintained.
There, my lord, what happened was,
because what they say is, my lord, there is some maser which we prepared. Please have a look at the maser. My lord, one cyclostyle form and file, my lord, after, my lord, 10 years after that it was filed by us.
Anyway, what happened to the appeal now?
I'm a private respondent. I'm an allotee under.
Paragraph 19 of the order of the learned single judge. My lord, there is a finding that is given page 75. Paragraph 19. My lord, page 75.
Volume
1. Volume 1, internal page 31. Order of the learned single judge.
The question whether.
Yes, my lord. Now this I will have to verify and I'll have to place it before my lord.
That's what we asked you.
My lord, that I'll have to place it before. Since it's coming up for the first time.
Lord may also consider reading from page 71, Lord, because on the question of possession and who has possession at an undisputed point in time is answered by the learned single judge. Because, Lord, they said they are in possession, but they couldn't have been because the road had already been formed there. In that.
So that inquiry about the title of the property,
No, no,
whether it
they'll
is
have-
forest land or private land is pending.
Yes.
That appeal is pending, but a portion of it was not.
Whose appeal?
His appeal.
His appeal.
It has to be. But anyway, till appeal is decided, then the status quo has to be maintained.
And we are in this appeal, if we decide, question will be decided. But your prayer for exemption from the acquisition is not on this ground.
No, my lord, sorry.
That question arises only if he succeeds in appeal. Otherwise, that question will not arise at all. It will be worse off.
But he is seeking exemptions from a different ground, standing trees.
My lord, according to me, my lord, it's not a forest land. Forest department claimed that it is a forest land, my lord. What happens is under the Karnataka Forest Act, they, my lord, initiate the proceedings.
Probably your case is that irrespective of the outcome of this appeal, you are entitled to exemption.
No. No, that can't. If appeal is decided in his favor, then it goes to consideration for exemption. Otherwise, it will not go. Because
Otherwise it will not.
No, but if the appeal is decided in his favor and it is found that it is
Even
not
if the
forest
appeal is
land.
decided against me, I will come before your lordship in a writ petition. My lord, please look at it.
Which one?
That is the whole.
Against, my lord, supposing, my lord, the appellate authority is who? The same conservator of forest. It is not, my lord, some high court judge or KAT.
Correct. What we are saying, we are discussing is your appeal against the order under 63.
Yes.
Is pending under 64.
Correct.
Capital A perhaps.
Yes, yes.
64A. Now we have already suffered an order. Therefore, you are in appeal. Otherwise, you would
Yes,
not
my
have
lord,
gone
absolutely.
in appeal at all.
Absolutely.
Yeah. Unless that, therefore, if the appeal, your whole fate depends upon the fate of the appeal. If the appeal says you are entitled to, then the case will go to parameters D of Justice Shantanu Gowda's order. Otherwise, not only. Because your whole case, as my lord has pointed out, your case was that you are in possession of the land, you have developed the garden, etc., etc.
Correct.
That my lord pointed out.
Correct.
That question will arise if you succeed in the appeal, statutory appeal, otherwise not.
No, can I put it in this manner, my lord, subject to my being corrected by your lordships? That, my lord, I was the owner of the land, Kata, revenue entries, everything is in my name, no dispute.
Correct.
Notifications in my name, award in my name. The writ petition, my lord, when it was allowed, if your lordships look at, my lord, the order of Justice Shantanu Gowda.
Protecting
Also, my
your
lord, is in
possession.
my name.
Protecting your possession.
Correct. That's all. I'm all the time saying, my lord, till then, my lord, please, my lord, ensure that, and state was a party there before Justice Shantanu Gowda. So, my lord, status quo, my lord, as on today, my lord, should be maintained by all the parties.
Mr. Rola, at least I am not clear.
I'm sorry, my apologies.
If the proceedings under section 63 are decided and it is held that the land is forest land, and what is your status?
Then, my lord, I'll have to challenge that. I'll have to challenge it.
His status is nobody
Then
because
you are-
of
you are-
Godavarman Tirumalapal.
You lose
You
everything.
will be nobody.
I will have to
Unless
challenge it.
that you challenge that order.
Unless- And you have challenged also.
And if it is decided otherwise, in your
In favor, my lord,
then
I am entitled to, my lord, the entire.
automatical,
Yes.
automatical.
No. Then BDL have to reconsider the representation.
But then, my lord,
Then it
BDA
will have
does
to be
not have a
reconsidered.
right. My lord, please look at it from this angle. BDA does not have a right. It says this is a
Then your petition was based on what ground?
Challenging notice.
My lord, I challenged it on the ground that, my lord, the land is a garden land and, my lord, it should not be acquired by the BDA.
Garden land is not necessarily forest land.
No, no, no. In fact, my lord, the trees, my lord, which your lordship sees that has been grown there, it's not a forest, my lord, growth. It is, my lord, what I have cultivated.
No, we cannot say all that because.
Anyway, my lord,
the statutory authority
I bow down.
has decided.
I bow down, my lord. I bow down to what falls from your lordship.
Appeal, the best way is that we can direct the consideration of the appeal in a time bound way.
Then thereafter what will
Thereafter,
happen,
what will, we cannot know. We do not know. That way I will say. In the event he
No,
succeeds
even
in
if it is
appeal,
decided in your favor, then it is
still
doubtful.
many aspects are there.
Many aspects are.
Too many ifs and buts are involved in.
There are two additional facts. The two additional facts are in a portion of the land which is not really part of the forest. A road had been developed. 1 point.
Anyway,
No, I'm just saying.
then suppose, assume he succeeds in the appeal.
Suppose he succeeds.
What should happen to his?
No, no, suppose he succeeds, his representation was to leave out that
Correct.
road land and then give it to him. Therefore, my lord, one clear fact which is admitted by them is the fact of possession having been taken. My lord, in his representation which he made pursuant to the order of his lordship Justice Shantanu Gowda,
What he has said.
he has said, give me all the land except the land taken for the road, which necessarily meant that the possession had been taken. Without taking possession, I can't make a road.
Therefore, question of protecting possession assumes it's on an inarticulate premise that he is still in possession.
Lord,
he admits that he is not in possession. Then he cannot say he seeks possession.
Then he can seek, my lord. But
the greatest respect, that is not correct. Then I ask myself this question, my lord.
They show your representation.
Yes, my lord.
Annexure K, my lord, page 387.
My lord, I had the benefit of a dispossession, my lord, before the learned single judge, before Justice Shantanu Gowda. For 10 long years.
But how you have structured your application?
Page
Please have a look at
390, last paragraph.
390.
390, last paragraph. Volume 2,
Two,
my
my
lord.
lord.
I'm sorry, volume 2. My lord. Volume 2, first document, actually. Hence, I appeal to your good self.
Exclude our
Further, I submit.
Acquisition procedures. This BDA has already developed a connecting road in part of our land. It's agreeable for me to retain the remaining portion of the land. No, he says, whatever road you have formed, etc., I want to retain the land. He does not seek possession back.
My lord, what I'm respectfully saying is, to form a road, I have to take possession. Without taking possession, I can't form a road. I have formed a road in various portions of the property, including his, and I produce the entire sketch, which is what the learned single judge my lord considers in the order and says, you are attacking a mahazar on the ground that possession was not taken, but admitting the fact that a portion of the property you had, they had taken possession to form a road, and therefore the argument on possession goes. That is a finding of the learned
Please
single
take, my
judge.
lord, the
But Justice Shantanu, you were a party.
Yes, my lord.
And the government was a party to the judgment of the other judgment of Honorable Shantanu Saab.
My lord.
Did you ever say that we have already dispossessed, at least make an observation wherever dispossession has taken place, they will not be entitled to
Lord,
protect.
it was a huge batch of writ petitions. But the fact, my lord, is maybe so. But
No, my
if
lord.
possession had been taken prior to the date on which he gets an interim order, then not the question of raising it or otherwise in my respectful submission will fall into insignificance.
That
Please see.
should have been your stand.
it was not their stand at all.
Lord, I understand. It's not the
Otherwise,
stand.
nobody's property will be safe.
True.
Perhaps you also own some property. Think about that also.
No, not one which can be acquired.
We are only we are saying what we say. We see there is an order. He is a party to the order. The order contemplated particular process. Process was almost, it was more than halfway undertaken, because you said let this land be deleted, of course, on the ground that it's a forest.
That's the only ground.
If it is a forest land, why did you take that possession and develop it?
Yes, my lord, there, my lord, the difference lies. The forest land, my lord, boundary ends at a point. The road is beyond that. And it is not, my lord, our statement. It is a statement by the forest department itself, where they've demarcated that land and said this is the extent. Now, therefore, the denotification, when we said denotify, it really meant not giving it up to the forest department. Forest department has enclosed that entire area and has retained it. Out of that, not certain portion was left out, which were formed into sites, which had been formed into sites then, and we had also produced a sketch or the entire sanction plan.
This was
Please
not
see
the-
page 71. my lord.
This was not the stand.
No, it was.
Not the stand before the learned single judge.
It was
before the, I'll point out.
Any order of stay at the hands of the appellate authority.
In the forest, this thing, my lord?
Yes.
Have you sought, before the appellate authority? Before that forest, this thing. Stay of the order passed by the single judge, they have that first authority. Yes, my lord.
Yes, sir, you have to file the papers.
We
can't assume on that.
1 minute, I'll just tell you.
I just pass on certain photographs which shows that the forest has already been demarcated out of the 10 acres. 7 acres is what the
To appear for whom?
private parties allottees under the BDA.
You will not be knowing the things.
We are put in possession.
Layout was formed.
Yes, my lord. And based on the allotments
With
and
the greatest
the
respect, no layout was formed. If your lordship is now, my lord, in fact, our application for inspection was filed before the learned single judge. It was, my lord, kept apart. Nothing, no orders have been passed. Because if there is layout is formed, there will be, my lord, markings. We said, please take that.
How layout is formed by the BDA? There is a normative process for it.
Yes, Lord. There, we have
all those things. Do we have those?
As a matter of fact, my lord, we had produced all the documents which show, my lord, that tender was awarded for the formation of the road as well as the layout.
Let us see.
All of them are there
Your
on
appeal.
record.
Please show how you have structured your appeal.
Huh? Because they want that. All right, just check.
My lords.
Anywhere have you stated that we are continuing in the possession? Therefore, we should be protected.
Yes, my lord.
Pendent a
Yes, my lord.
appeal.
Please come to my lord, my application itself, my lord.
No, before the appellate authority.
Appellate authority, my lord.
Statutory authority. Because that decides the title, because of Godavarman. That authority decides the title.
The very proceedings are for
Proceedings
that.
are for that purpose. Forest Act.
And then I'll use it tomorrow. Thereafter, what happens?
Perhaps appeal is under 64 capital A2. A2. But it's a forfeiture.
There must be a provision for deciding.
I beg your pardon?
Same.
That's all right. Private.
Your appeal is under which section?
My lord, appeal is my lord under the 60.
Lord, the order says, order of his lordship Justice Aradi says 64A3, my lord. I'm not sure if maybe that's a mistake.
May not be. May not be because there is no forfeiture. Forfeiture is a different concept.
No, this is what my lords are saying. This may be a mistake. Do you have a copy?
It appears to be a mistake.
Yes, Amatra.
It cannot be because it's not a case of forfeiture, vehicle, goods, etc., which they forfeit in that. But appeal appears to be under, you have filed appeal. It's your appeal. Under which section you have filed?
My lord, can I not, instead of wasting a lord's time, have it tomorrow, day after tomorrow, my lord, we'll produce that.
No, no, we'll keep it, but let us be clear about our road, future road. Now, this appeal is pending. Appeal was decided against you by the.
Appeal was not decided against you.
Conservator of forest. Then you file a petition.
No, my lord, what happens is the first.
Go to page 74.
Yes.
It is stated in the order of law in a single. So 27/10/17 was the order of appellate authority whereby you are required to vacate the encroachment. So the very land. Then you filed a writ petition.
Yes, my lord.
Which was disposed of, quashing the order dated 27/10/17 and directing the authority to reconsider the.
My lord, 474, is it, my lord?
No, 74.
74, my lord, I'm sorry,
74.
my apologies. my lord.
So that aspect is resting at that stage, remand.
Remand. It cannot be, there are no two appeals that way. Appeal is in respect of forfeiture, etc. This is the only section.
Memorandum of appeals.
Sorry, my apologies. One ನಿಮಿಷ ನೀವು ಅಲ್ಲಿ paper ಅಲ್ಲಿ ತೆಗೆದು. Vacated the encroachment. Then my lord came that.
No, this
Radha's
appeal,
order.
this appeal will decide your title.
It decides title.
So then.
The courts have held that way.
This order, my lord, of the appellate authority was
And remanded.
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 Still pending.
Yes.
So that will decide your fate of, that's your fate.
That's why. Because of Godavarma. The authorities constituted under Act will decide title to the land also.
And the subject matter is entire land.
Entire land.
Entire. Not
There'll be a small portion which will not form part of the forest. A small portion.
That is road part.
Road part and some sites.
No site, my lord.
There are
no
some sites which are
That's why, my
allotted
lord,
and sold.
Even now, appoint, my lord, any lawyer, let him go and inspect. If there is a site, my lord, I will withdraw the writ itself.
I'll
our
just-
writ appeal.
This will go against the senior counsel submission, the photographs which are taken.
Anyway, everything.
Today you are occupying the land.
Please, my lord.
You are in possession of the
Yes, my lord. Because I had the benefit of, my lord,
We are in
interim order
possession
throughout
of the
from
property.
2003 onwards.
Photographs clearly
Continuously.
demonstrate.
There are sites. Commissioner can be appointed.
Depending upon outcome of the pending appeal. Only one page.
Photographs clearly demonstrate that we are in possession of the property. The allotee is under the
You
BDI.
cannot decide who is.
You are
in
allowed.
possession.
Yes, my lord. The sites
But
are
forest
allotted.
land?
We have, yes, my lord.
According to them, my lord, it's a forest land.
No, no.
No, it's
BDA
not the
says it's a forest land.
But the, after
When
demarcation,
you-
it was
when
found
you are
about
allotted-
7 acres. and
When
all-
you are allotted,
We are allotted in 2007. I've just produced the sale deeds along with
What kind of allotment?
site, Your Honor,
PD allotted.
From BDA.
PD.
After there was a demarcation by the
Forest Department.
Forest Department,
In your appeal, did you seek any interim order for protecting in terms of Justice Shantangowda's order?
Yes.
It's a statutory appeal.
Yes.
Where is that? Sure, sir. Please show.
Adan Tankurting. That's what, my lord, they didn't bring it today. I'll show it to your lordship. No difficulty. In fact, I had the benefit of, my lord, interim order throughout from 2003 onwards.
Position was taken before 2000. So you want time for what?
I'll just show it, my lord, since your lordship has asked me this question.
Yes,
Otherwise, my lord, I had the benefit of an interim order, my lord, throughout, even before the learned single judge, my lord, who dismissed my writ petition.
So we are narrowing down the contour.
Very well.
may just leave. We just leave these photographs, which will just show that.
You have to bring that judgment of apex court, that there is one good book on that. Rutvik Datta and Bhupendra Yadav, they have compiled all the judgments under the Godavarman. In one judgment says what all the authorities will do under the State Act.
I'll get.
And latest judgment also.
Yes.
Now this appeal is, which is pending, is under which provision?
That is 63.
No.
63 is different. We have produced, we have filed it for under 63.
63 is little different.
Because they said, my lord, this land is forfeited, so my lord, we filed it.
The appeal which is remanded is under which provision? Power to release property seized under section 64.
64A1.
Huh?
Yeah.
There is an appealable, there is a provision for appeal.
Your appeal is, Mr. Hall, under which provision?
My lord, 64A.
64A,
Capital
3,
A.
my lord.
Capital
A, I three. think, my lord, the first part is 64A. Please see subsection 1. Any person unauthorizedly occupying any land in reserved forest may without prejudice so and so maybe summarily evicted. Against that, appeal is 3.
3. Any person agreed with the
Order made under subsection 1.
A3. You're right.
Forest officer passed that order. Against that, my lord, under 3.
Fully decides the title.
So the forest officer passed an order, my lord, they are unauthorizedly in occupation, against which an appeal. Appeal is against him. Then, my lord, writ petition matter remanded back. That's where it is today.
Whether the order passed under 63A1 is set aside?
64A1.
64A1. 3 having been set aside remanded?
Yes.
Or 63A1 having been set aside?
Not 1. So 1 continues. And he has succeeded in the appeal. Because not the appeal is set aside, because the appeal affirmed the order of the forest officer. So the forest officer's order remains intact today. Therefore, until he succeeds in the appeal, he cannot claim. If he succeeds, and let's say about everyone else upholds the order of the court, then the BDA may have to consider as per that judgment.
But we do not understand how you could form layout having said that all this is forest land.
That is because the survey was done and the exact contours of how much of the forest land was identified. And then a portion of the land was left out.
With the
as not
greatest
being
respect,
forest.
even that is not correct. The whole land is not sought to be deleted on the ground that is forest land.
That is true. That is what we recommended.
You represent whom?
BDA, Bangalore Development Authority.
In fact, the earlier order was set aside because if you
Your submission is a double-edged knife.
Yes.
Which you will reveal on the next day.
I know.
Obviously. It has to be like that.
But that's the fact. I'm just placing the facts before my Lord, as they are.
Correct. So what?
When do you?
Well, tomorrow itself,
Choose.
Yes, we'll have to give it. Otherwise, in the afternoon also, I can give it.
No.
Whatever, subject to your lords. I know the pressure on your lords' court. But
One day, 2 days.
2 days. Wednesday.
Wednesday.
Next Wednesday.
Next Wednesday. Allah, 2 days.
2 days.
Friday. Thursday.
Very
Thursday or
good
Friday.
point.
Anyway.
Though it's we are
Bulk.
it's very, very bulky.
Because one judgment runs into about 200 pages. Then translation, all that.
Learned judges notice the crux for the last paragraph.
Yes.
That also, I'll point out, that is also not correct because we have the Google map. All this marking, when they have only made it. It is not there. That's why we filed an application for inspection through a.
Why Google map was used to show
there are
forest
farm. We have the Google map.
To show ultimately that there is a clear boundary demarcated by the forest department, showing till what point is the Turahalli forest. So the forest had to be protected. After that, what is left of the land, of course, will fall for some consideration.
There is no left. Entire land is denotified.
If it is not a forest land, your argument again, if it is not a forest land where you have developed, then it will be a private land because you have notified for acquisition.
No, I've not denotified. I've not denotified. It is a recommendation which has not yet been accepted by the government. Therefore, to that extent, it still remains as it is.
But therefore, but you have notified it in his name.
No, that is true. In so far as the balanced land is concerned, the notification will stand in so far as that land is concerned. Then the question will be what will happen to that portion of the land of which possession has been taken and road has been formed already. Then he'll only be entitled to compensation for that land, nothing more.
Question is, whether.
Yeah.
Yes, let me not waste your time.
Latest judgment. Bring latest judgment of Godavarman also.
Yes, I'll find those.
With the expanded contours of concept of forest.
It was the earlier view. They reiterated because there was that Lafarge this thing.
Correct.
Where they held that merely because there is tree growth, it can't be treated as forest land. Because if that is done, the Supreme Court also held, then Luton's area will have to be treated as forest land.
Luton's area was.
They held. That's why. But then now they again reiterated the earlier view.
But that is also.
Anyway, we don't know where we are heading. Anyway, it's grateful.
Very good.
Certainly not in the forest.
Number 28.
Lords, I have sealed an auction notice, my lords. Auction notice on my land, my lords. It's an agricultural land which I have procured in 2004 and I inherited from my husband in
But
2000.
iron ore is lying on your land.
My lords, is what they are saying, my lords.
Then they're auctioning it.
My lords, without, my lords,
How the iron ore lying in her land?
Because it has been dumped on their landlord
Why?
by MEL, the earlier leaseholder.
My lords, this area is an agricultural land, my lords. And the notification which clearly says
Is
that,
it whether that ore belongs to you?
no, I'm not
Belongs
disputing.
to them.
My lords, not disputing.
Now, what is your prayer here?
My lords, my prayer is at least give me an audience, come inspect that area, demarcate this
Prayer
area.
is to challenge to the notification, that auction notification,
lord.
which is scheduled tomorrow.
My lords,
How
what-
you are
my
concerned
lords,
with the
I
goods?
concede to the fact that the subsoil, whatever material is on the subsoil is the property of the government. Not disputing that. My lords, I am disputing the procedure what has been adopted.
Now, if you agree
My lords.
that these minerals which have been won
Yes, my lords.
are stored in your land, heaped in your land, you do not become the owner of
My
that
lords,
under law.
my lords, my only thing is, I don't know whether this is a iron or mud or what is it.
Where have you stated? It cannot fall from some like meteor. Or you have to say whether you have mined it,
No, my lords,
then leave it.
I have not minded.
Then where is your right to interdict the auction?
All I'm asking, my lords, if they would have followed the procedure and come and inspected this area and found out that there is this quantity of material, I would myself would have found that would have demarcated, and at least I should have given an audience before.
What is your right? Where have you structured your petition on the premise
Please, my lords.
that what has been heaped on your land belongs to you?
No, my lords, I'm
Then
not.
do you let it be auctioned?
Wait, my lords, all I'm asking is, my lords, at least I should have been given an audience, my lords, is what all I'm asking before auction.
Someone's jurisdiction. Tapering to the center of the earth and up to the heaven. We call it Ed Cooley. But that concept we have not accepted. We have made all something what have been inside the subsoil belongs to the state. Even if it is private land. That's what.
Only I'm asking, my lords, is
That's nothing.
My lords,
Right.
principle of natural justice could have been followed. At least I should have been notified. I am in this possession of this land from 2004, my lords. Nothing has happened, no notice, either if they would have, it is there.
It's not your case
Yes, my lords.
that I have the goods that have been heaped on my land
Yes.
belong to me. It's not your case.
My lords, any material which is on the subsoil,
Belongs
we have a right, my lords, on the subsoil. Topsoil, my lords, it's whatever is dumped, it will be the property of the government. My
No,
lords,
no, no.
all
Mineral
I'm
belongs
asking-
to the government. that's
Always
what,
it belongs
Please,
to
my
the
lords, that
government.
I am not disputing. All I'm asking, my lords, demarcate this area which you are taking, whatever.
They are not taking your land at all.
No, my
They
lords.
want to auction the minerals that have been heaped on your land.
My
That's
lords,
all.
but-
You may do it and remove it immediately and give back that.
Yes,
Don't
yes, sir.
trouble them with that one.
My lords, all that is what I'm asking, that you please come inspect this area.
Now,
in my
this iron
presence.
array, madam, is lying since 2005 in your land.
Yes.
2005?
My lords, CEC has come in 2011, my
And all
lords.
of a sudden you are waking up in
No,
from
my lord, I
slumber
didn't wake
because
up,
some
they
auction.
woke up, my lords. They woke up in 2024, my
Have
lord.
no substantive right at all.
My
You
lord,
can't interdict the auction of the government property. It's a government property.
my lords, no dispute about it. All I ask is,
Only concern of the petitioner is that not while removing, we will damage the land.
That you cannot damage.
That we will not do. 42, page number 42 is the representation. Para 3 may kindly be.
Heard
seen.
learned advocate Miss Anuparna Bordoloi for the petitioner and learned government advocate Mr. S.S. Mahendra for the respondent state and its authorities. Paragraph, by filing this writ petition under Article 226 of the Constitution, the petitioner has prayed to set aside letter dated 4/3/24 insofar as the commodity is situated on the property of the land property of the petitioner is proposed to be dealt with by the said letter. It is further prayed to set aside the tender document populated by respondent 3. the impugned letter reflects that it is an e-auction notice, whereby the Department of Mines and Geology has proposed to auction the commodity, which is iron ore lying on the land property of on the land of the petitioner. Paragraph. The case put forward by the petitioner. Yes, anything? Yes, in the writ petition is that the land bearing survey number 38/PI, P1, and land bearing survey number 38/P2 at Dina Dahadali village, Hireguntaru, Hobli, Chitra Durga, were purchased by the petitioner under a registered sale deed dated 23/4/2004. It is stated that the said property is an agricultural land, and the petitioner and the family members have been carrying out the agricultural operations over the property. It is further the case of the petition. It is further stated by the petitioner that during the year 2005, Railway Department, while putting up the railway lines near the petitioner's land, dumped the iron ore on the petitioner's property, and that ever since then, the iron ore has been lying on the property, on the land. Paragraph. Respondent number 2, Director, the Department of Geology and Mines, has now notified for auctioning of the said iron ore lying in the property of the petitioner, which is the impugned notice cum letter dated 4/3/24. The auction is scheduled to take place on tomorrow, on 20th March 2020. The grievance of the petitioner is that the activity of auctioning the iron ore to be undertaken pursuant to the auction notice will damage the crops and vegetation on the land cultivated by the petitioner. Petitioner seeks opportunity of hearing. Not only that, the petitioner has prayed to set aside the auction notice itself. Full stop. The facts pleaded by the petitioner themselves unequivocally indicate that the iron ore has been lying on the land of the petitioner since the year 2005. Full stop. Till that time, no complaint, no voice of complaint has ever been raised by the petitioner. Admittedly, the commodities or goods belong to the ownership or respondent to the Department of Geology and Mines. The full stop. Respondent 2 has on its own right proceeded to auction the property, and for that purpose the impugned auction notice is issued. Paragraph. In the facts of the case, comma, the petitioner does not have a semblance of right, much less enforceable right, to arrest or interdict the process of auction. Full stop. It is extremely doubtful that the petitioner can locus to challenge the auction notice and prevent the respondents from auctioning the iron ore lying on the land of the petitioner belonging to respondent 2, since 2005. Full stop. Paragraph. The entire grievance is misconceived and is not supported by any right with the petitioner to seek such prayers. Also, the petition is meritless. It cannot be entertained. The same is summarily rejected, dismissed.
Please let them not damage the property is what.
For that, there is a provision which you have to go for that.
So ultimately, you are
Provision.
Yes.
complaining that only. File a suit if it is.
Yes, I accept notice for the respondents. I accept notice for.
We have
the
recorded.
Okay.
The learned second paragraph, learned government advocate accept the notice. The petition was taken up for final consideration since both the parties.
May I make one
To
submission?
their respective advocates. Yes, yes,
So I would like to withdraw a writ petition at serial number 33, my lords,
33.
and liberty may kindly be granted to me.
So read petition number 24439/22, learned advocate Mr. Ravindra Gajanan Kole. And
Objection.
files memo.
Yes, my lords.
Withdrawal.
I have filed memo stating
Indicating
that
that he is, showing that he has instructions
during
to
the
withdraw the
pendency,
writ petition. And in accordance with the instructions from the petitioner, he seeks permission to withdraw. The
And
memo is
similar-
taken on record. The petition is dismissed as withdrawn.
similarly 71, my lords.
Notice is discharged. Similarly, 71, same order.
The Lordship, serial number 23 and 73.
Same order.
29 and 73.
Next matter,
Same
they
order.
have filed IA. I want objection.
We are happy if you are withdrawn.
First,
File objections, my lord.
first week,
Next
Lordship.
matter, 29.
29 and 73.
Second week of April,
73,
29 and 73.
73, we are appearing for a.
So what do you, what do you want?
Model
They
is
have
there to be.
They have served IA today. We want to
On
file
time.
objections.
It is now been filed in a particular format. I am appearing for him. IA has been already served, Miller. It has been filed in a particular format. Anytime Miller convened to the court.
First week, Lordship.
Next, second
Somehow
week of
you
the
want-
April.
Second week
Second
of
week.
April, 15th April.
Please.
15. 29 and 73.
Interim model is there in the 73 to be extended.
15.
Number 30. Narendra HN.
I appear on behalf of the accused number 1.
Hearing to the government.
I am for the respondent one in the writ appeal matter, and then complainant in the connected matter.
It's a humble submission in this matter, my lords. I appear on behalf of the accused number 1 in the contempt petition. Lords, we have filed an compliance affidavit along with few documents, my lords, which is in Kannada version. The Honorable Court, my lords, grant us some time, my lords. We'll file our typed copy, my lords.
So you are the society?
School, my
Trust,
lords. Yes,
trust.
yes, yes. my lord.
So nothing wrong with in the judgment of learned single judge. You never even served charge sheet and dismissed the.
No, my lords. In this, what has happened, my lords, in the writ petition,
Translation. Do you think translation necessary?
please, my lords. Humble request, my lords. 2 weeks' time or 3 weeks' time, my lords.
Fine.
My kind submission in this particular regard, my lord. I am for the respondent in the writ.
We
appeal.
let him file it, satisfaction of arguing in it. Yes.
Grateful, my lords.
2 weeks? 2 weeks?
Please, my lords.
2 weeks, to file it.
As far as the.
Who is for the society?
I
You are
appear,
for this.
yes.
Oh. All right, 2 weeks.
Grateful, my lords.
My kind submission, my kind.
Date will be?
Because I am for the respondent one in the said appeal.
Yes.
They are not supposed to file this appeal at all, my lord. This is my kind submission because while conducting an inquiry, they have not at all issued any charge memo to
It
me.
is what we told, but let him.
He wants to file a translation.
Doesn't matter. By for.
You are reinstated,
payment of-
you are reinstated?
Yes, my
Are
lords.
you reinstated
Yes,
now?
we have him
Then where is it?
himself.
I am reinstated, but 1.5 years salary has not at all been paid so far. Already 1 year and 2 months over. Date of the order was January 23rd.
Sessions always pays. Wait. Let him take up after the translation is supplied,
Please, my lord.
right?
Grateful,
Yes.
my lords.
31. Shevi Gangadharappa.
And a date may kindly be given. Date. Third. Wait, my lord.
I am for the appellant.
Who appears? Yes.
This is also connected with serial number 65.
61,
65.
65.
Both go together because common order is passed in 2 writ petitions.
So 65 arises of same judgment.
Same order. Common order has been passed by learned single judge. In
So
2 writ.
Uma Devi is applied. Paragraph 52 of the judgment.
My submission before this honorable court is.
For appellate bench, there is no. Oh, no.
There is nothing on
He is
record.
working since 2014.
Yes.
They have abandoned the service.
Hmm?
They have abandoned the service in October 2010, 20.
How many persons are there? Only one?
Only 2 persons.
Only two
Only 2
persons.
persons. Of course, there are regular employees so far as the Patan Panchayat is concerned.
Serving for 13 years. From
Gram Panch-
2010.
They were
Without any
initially,
break. That is the case.
that is the case pleaded by them.
Post Uma Devi. Uma Devi judgment. Yes, it falls into 53. Without the order. Without the order. Without etc.
Yes. So he-
Those government orders do effect to the non-application of the you can remove the
There are no records produced either by the petitioner or by the respondent because the resolution book and connected records relating to Gram Panchayat, they have not been handed over to the subsequent chief officer on account of the upgradation of the Panchayat as a town Panchayat. It was previously Gram Panchayat, and Gram Panchayat came to be abolished, replaced by town Panchayat, which is under the Karnataka Municipalities Act. A complaint has been lodged with the jurisdictional police regarding the fact of not handing over the relevant documents, and therefore I made a submission before the learned single judge that unless the documents are made available, it's not possible to make any submission. with regard to this.
This is coming for the first time?
This is for the first time. It is.
Today is not in service? He or
No,
she?
they are not. They are not.
They are not in service?
They are not.
They had abandoned the service.
That is our case. They abandoned the service because they were not regularly appointed. Intermittently, whenever there was a number of personnel to handle the waterman work was not available, these persons were.
They must be in service.
Our learned advocate, Mr. Ganga Dharappa. For the appellant, notice returnable. After
Lord, I
vacation.
take notice for respondents 2 to 5.
Learned additional government advocate, Mr. Miss Nilofer Akbar.
2 to 5.
Waives accepts notice on behalf of 2 to 5.
Seeking for interim order. Seeking for interim order of stay of the order passed by the learned single judge.
What stay?
They have been ordered to be.
But he is not in your service.
They are not, of course, then I will have to face the contempt proceedings for non-implementation of the order
Passed by a single judge in the impugned judgment and order shall remain in abeyance.
Much obliged.
Till the next date of posting of.
But there is a delay.
No, there is no delay.
There is delay.
Delay of what?
Therefore, no order can be granted.
Sorry, I stand corrected.
Take emergent.
I shall.
So in 65 also same order.
Yes. Both are connected.
Both.
And arising out of the same order.
Yes.
Number 32, Mr. Nanda Kishore.
I humbly appear for the appellant. My lords, in this matter, I'm seeking a short accommodation because the arguing counsel, learned senior counsel who was appearing in the matter, my lords, today is his mother's ceremony. Seek a short accommodation. My lords, it's a matter which involves an acquisition. Learned senior counsel who was engaged arguing the matter, today is his mother's ceremony. Next week.
After 10 days.
Yes, much obliged.
Not one respondent is deceased now. They will have to take steps so that the matter can be heard next.
Yes, I will take steps for deceased respondent 5A.
Steps to be taken.
For
by-
22 years, no award is passed.
Unserved respondent 5.
Yes, my lords. Yes.
And the service shall be effected before the next.
Yes, yes.
33 disposed, number 34. Mr. Raghavendra G. Gayatri.
Appears for the appellant. Selection to the post of telephone operator. That one of the conditions prescribed by the in the notification at page 60, one must have passed the SSLC or equivalent examination, or and should have studied Sanskrit language in SSLC. The selected candidate worked in the university as a group D on contract basis from 2009, and later he was also worked as the junior assistant. He completed SSLC in the year 2006, and Kavya and Sahitya he completed in the year 2016, during the period in which he worked in the university. 2012, my lord. My respectful submission is, my lord, last occasions after the argument, after noticing the marks awarded in the interview, my lord, the original records were called from the university. By the, as per the order of the court, my lord, on 12/7/23, my lord. Original records were called for.
No, only issue is about the, whether the third respondent was possessing the equivalent qualification or not.
But my responsible submission is, my lord, selection process is,
Kindly listen. Equivalent qualifications prescribed by the government.
my lord, as per
Is
the
there. It is there.
notifications, my lord, Sahitya is.
There is notification, which
But-
is annexed with the statement of objections.
They
And if it
they
is-
have produced, madam, produced, they have
If the
produced.
employer himself has recognized a degree to be a degree or qualification to be equivalent, then you
But
can't say that.
There is twin conditions in the notification. Kindly come to page 60, my lord.
60.
Page 60 of the notification, translated version, where, my lord, SSLC are equivalent qualification. My lord, in addition to that, one more prescription is there, my lord, where should have studied Sanskrit language in SSLC. My respectful submission is, my lord, selected candidate, no doubt, but having Kavya and Sahitya and SSLC, but he has not studied Sanskrit as a language in SSLC.
Where is the requirement?
Page 60, my lord. Page 60,
So
serial
passed
number 6, my
SSLC or
lord.
equivalent examination?
Yeah,
should
must
have
have
stu-
passed the SSLC or equivalent examination.
They have studied.
Full stop, my lord.
Language in SSLC.
Then, my lord, should have studied Sanskrit language in SSLC. He studied SSLC in the year 2006, Kannada as a first language,
Not Sanskrit.
not Sanskrit, and completed Kavya and Sahitya after 6 years, my lord, in the year 2012, while working as a group D in the university.
No, what difference it makes? He acquired, made value addition subsequently. Where is the requirement that that value addition should have been as on
My lord,
that particular
he
day?
should have studied, my lord, Sanskrit, my lord, in the SSLC only. That is that. Otherwise, my lord, second conditions become redundant.
So he has not studied the Sanskrit in the.
SSLC, my lord.
Then what is that Kavya and Sahitya?
Kavya and Sahitya, as per my lord 1967 my lord notifications, it is, my lord, treated as equivalent to secondary examination.
Secondary examination.
Secondary, they state, my lord, in the notification, lordship may see.
It is equivalent to SSLC only. If he has Kavya and Sahitya, it is as good as SSLC. That is the object. Other, where is the requirement? If he has studied
Kindly see,
language.
kindly see, my lord, that in the, while awarding the marks, they have taken into consideration only SSLC.
Kavya Sahitya is studied in Sanskrit.
Yes, my lord.
Yes.
Yes.
Kindly see, my lord, page 259, awarding the marks, they have taken only SSLC.
Kavya and Sahitya is recognized as equivalent to this
Yes, my
secondary
lord.
school
Yes.
examination. And in that, in this equivalent, he has studied in.
Page number 114. Kindly see page 260, my lord.
So really rightly recognized to be.
At 260 marks awarded by the selection committee, my lord, where, my lord, same date written examination, awarded 25 marks in the written test, and also, my lord, they awarded marks, my lord, in the interview on the same date. No select list is published, and no, my lord, they issued the appointment order next day itself. Kindly see, my lord, 260 page for a moment. SSLC, what is considered by the selecting authority is only marks awarding in SSLC, not consideration of Kavya and Sahitya.
Solid. As on that day, he was selected.
Please.
Was he having that certificate of Kavya and Sahitya?
Yes.
Yes, he is having the Kavya and Sahitya certificate, my respectful
Therefore,
submit.
this ground which you are urging, that he lacked educational qualification, has to fall to the ground.
But otherwise, my lord, in the notification, they should have stated SSLC equivalent with Sanskrit.
No, the very purpose of the second notification, which you have produced.
Page number 189.
See, page
Please see
69.
page number
Kindly
189.
see the page. Once again, I'll read the notification, my lord. Must have passed SSLC or equivalent examination. There is a police stop.
Page number 189.
Then, my lord, kindly see, my lord, second condition should have studied as some language, Sanskrit language in SSLC. He has not studied at all.
This shows, my lord, equivalent.
No, there is nothing like Tripitika, which requires repetition again. He has said that. He should have studied Sanskrit as one of the subjects in SSLC, which he has not. He took Kannada. The second one, which you said is, he should have equivalent examination to SSLC. In SSLC, you should have studied some.
Kindly see, my lord,
These are the only two.
I secured, my lord, higher marks in the SSLC. My lord, 490, he secured lower marks in the SSLC.
What was your
My
score
marks,
and,
kindly see, my lord, my marks, I will show the my marks card. I have secured, my lord, in the SSLC, my lord, 496 marks. On the other hand, the third respondent secured, my lord, only, my lord, 219 marks, 293 marks in SSLC.
This is the Sanskrit.
Kindly see, kindly come to page, my lord, 126. My marks is, my lord, page 72, SSLC marks card, my lord, 496. He secured, my lord, 293. And he worked in the university, therefore, my motion has been made, conducting written examination on the same date and putting, my lord, 24 marks in the written examination.
Where is this Kavya and
But page 112, my lord, says 112, my lord, page number 112.
no, in this page 190, it is not indicated.
No, it is an objections. My lord. Objections filed by the third
Lord,
respondent. 112, it is relevant.
Page number 112, my lord,
Page 190.
112.
No, page 190.
190, yes.
There it is not indicated. It is the append, it is something appended to that notification.
This is the statement of objection.
I think,
Relevant.
Name of the examination.
yes, my lord, there, my lord, shall kindly see serial number. Yes, my lord,
there.
government of Mysore.
That is-
Government of Mysore, my lord, earlier.
Now you are showing page number
Oh, same thing, my lord.
122.
There is some mistake in the pagination, my lord, which is
Doesn't
given. Same
matter.
notification is there in, my lord, 112.
One-
Page number
114.
114, my lord, same thing, my lords will see at serial number 8.
Eight.
Serial number 8, my lord. I am referring to the same notification. So that equivalence is there already, my lord, by way of a notification issued by the government of India.
My submission is, my lord, the entire selection process.
We are
That-
processing your arguments. We are processing your argument. You have to give some time to the listeners.
Please, I'm sorry, I apologize.
Higher secondary is SSLC.
Yes, please.
Is there any score point in that Kavya and Sahitya?
Yes, my lord, marks are there.
What are the marks?
Not a 260 page, my lord. In the marks list awarded by the committee, my lord, that is, they have highlighted their marks, my lord.
In Kavya and Sahitya, what is the marks? What are the marks?
Lord, Kavya, my lord, he has received 73.05%. And Sahitya, my lord, 63.08%. In the written test, my lord, in the written test, my lord, the appellant has secured 9 marks. And my lord, the successful applicant who is appointed, for which my learned friend appears, my lord, he has got 24 marks. 9 and 24. 9 marks in the written test, and the successful candidate who is appointed 24. In the interview, my lord.
That is third respondent.
Pardon, my lord?
Third respondent.
Third respondent, yes, please. Third respondent. In the interview, my lord, 3 marks for the appellant and third respondent gets, my lord, 9 marks. So overall assessment, my lord, by the committee is 19.9 for the appellant and for the third respondent, 38.7. His only principal grievance is you can't treat this as equivalent. There's a notification. That notification has put the test of time.
So your comparative merits will be?
Comparative merits will be, my lord, 19.
He will be more meritorious.
Yes, my lord, undoubtedly, my lord. 19.9. So far as the appellant is concerned, it is out of 50 marks, my lord. And in so far as the third respondent is concerned, my lord, 38.7.
Why he was selected and why not he?
Lord, because, my lord, of the assessment made, my lord, overall assessment, that is written examination, interview, educational marks, all of them are taken together, my lord.
In written examination, how much?
Written examination, my lord, appellant gets 9.
Ah,
Third respondent gets 24.
24.
Out of 25, my lord.
Yes, out of 25.
25.
Out of 25. In the interview, my lord, appellant gets 3. And respondent number 3 gets 9, my lord. This is out of 10 marks.
Ah.
So therefore, my lord, overall assessment.
And in educational.
Educational qualification, my lord, the appellant gets 7.9 out of 10.
7.9 out of 10. And
My lord. Respondent number 3 gets 4.7 out of 10. So even if his grievance is taken notionally and further 6 marks is given because maximum that can be awarded is, my lord, 10. Even if 5 marks additional is awarded, it does not make up the difference.
any allegation you have made against the selection committee?
No.
You have not.
I have not made any specific allegations, my lord, in the writ petition. But, my lord, in the writ petitions, in the statement of objection filed before the learned single judge, they have not at all, my lord, initially they have not at all stated about, but awarding of these marks.
Now they have stated, if you had made some, which is that judgment of the apex court, the Emiti Maya.
Please.
If you have not made any allegation against the selection committee, then you can't say so much marks could not have been given to a particular candidate because you have full faith in the committee itself.
That is followed in Tajveer Singh's latest judgment.
Correct, latest judgment.
Tajveer Singh, 2023 live SCC 253. All the judgments on the point have been reviewed. I just come along, pass over.
Specific allegation is not found in before the single judge.
They have not
in the
made
writ
any.
petitions.
But you have not taken foundational facts, you are not pleaded. In such matters, you should have said, the committee did not work, so particular persons were inimical to me, inimical to my community. Something like that you should have taken. Then we could have entered it.
What my lords are saying, my lord, is found in para 9.4. Para 9.4.
Very liberal.
The comprehensive judgment, my lord, covering all the up to date. Para 9.4.
My lord, in para 9 of the rejoinder, my lord, filed at 2002. I'm sorry.
He's arguing.
I'm sorry.
9.4,
9.4, my lord.
page.
Sense of
15.
1.5, my lord.
in absence of any mala fide
Yes, my lord. Yes, please. That is what my lords were.
or
referring to.
bias.
Also delay, my lord, in filing the petition. 2 years after the appointment, my lord, writ petition is filed. 2 years after the appointment is made, my lord, writ is filed.
Whether probationary was declared?
Yes.
Declared?
Yes.
When it was declared? Then where do you stand?
Page 202 of the, my lord, rejoinder filed before the learned single judge, my lord. I have taken at para 9. So thus the second respondent was interested in appointing the third respondent for the post in question.
You could not have taken it rejoinder. The division bench has said, in rejoinder, you cannot improve over what has been stated in your petition. Yes, that's the law. There is one judgment of the division bench.
But your lordship, my lord, last occasions after the argument, my lord, the bench has called for the records to know that how the selections were taken place. Because at the initial stage, they have not came up with this marks at all. In their reply statement.
What is your explanation for the delay of 2 years?
Lord, I obtained, my lord, in the rejoinder statement, I have clearly stated, initially I could not, my lord, get the.
In the petition, delay should be explained in the petition. Because by petition you came to the court.
It is not stated in the petition. It is stated in the only in the
Probationary
rejoinder.
is also declared.
In the rejoinder, it is stated.
Probationary was declared, my
That's
lord,
useless.
3 months after filing of the petition.
After filing
Yes,
of the
yes.
petition.
What is declared?
probationary period.
Probationary.
Yes.
It
Now
is
he has
regular.
been
Probation period is
working
over.
from,
But my lord, if you lordship see the records, my lord, it's maxed my lord illegality. Because he worked there from 2009 as a group D, and 12 and 13, my lord, he was my lord, continued on contract basis as a junior assistant, where he completed my lord Sahitya, and one day morning test conducted. On that day itself, interview conducted, select list is not published, and also, my lord, they issued the appointment order. On the next day.
Sorry, come with the better matter. Yes.
And persons, my lord, who were in the part of it, my lord, in the registrar and something, I am heard, my lord, they were, my lord, no, terminate, their selection itself is terminated. The persons who are involved in the main persons, deputy registrar and in other case.
Can we proceed to dictate the order? Writ appeal number 555 of 23. Heard learned advocate Mr. Raghavendra G. Gayatri for the appellant. Learned advocate Mr. GB. Learned government advocate Miss Additional Government Advocate Miss Nilofer Akbar for respondent 1 and 2. Learned advocate Mr. Abhinav
yes,
for
Abhinav R.
respondent 2 and learned advocate Pavan Kumar for respondent 3.
Yes.
Vivekananda appears for?
Well, he
Pavan.
appears for
Third respondent.
Third respondent. I appear for the Sanskrit University.
You are Pavan Kumar.
Third respondent.
For respondent 3.
Nandish.
Nandish, my lord. His name is Nandish. Nandish.
The challenge in this writ appeal filed under section 4 of the Karnataka High Court Act 1961 is addressed to judgment and order dated 20th March 23 of learned single case, whereby the petition of the appellant petitioner came to be dismissed. What was prayed in the writ petition by the petitioner appellant was to set aside the order of appointment of respondent 3, who came to be appointed on the post of telephone operator. Paragraph. The facts in the backdrop were inter alia that the petitioner and respondent 3 both were the aspirants to be appointed on the post, which was advertised pursuant to, which was advertised as per notification dated 8/11/2017 by respondent 2 University, this for Karnataka Sanskrit University. The notification, recruitment notification dated 8/11/17 described the eligibility to the post of telephone operator. The qualification needed were paragraph. That Roman small 1, the candidate must have passed secondary school. What is SSLC? Secondary school leaving certificate examination or equivalent examination. 2, the candidate should have studied Sanskrit language in SSLC. 3, the candidate must have undergone the training in PABX. 4, it was provided that the preference would be given to the physically challenged. It was also the requirement for that he should have studied Sanskrit language in the SSLC examination. As regards paragraph. The requirement of passing SSLC examination or equivalent examination, comma. the Ministry of Education, Government of India, issued has issued notification dated 23rd January 1964, providing for equivalence of Sanskrit examinations. The study in Kavya Sahitya is treated to be equivalent to passing of SSLC examination. The notification figures on record of the petition having been produced along with the statement of objection by the respondent. The challenge to the appointment of the respondent 3 to the post was primarily and mainly based on the contention that the petitioner had passed equivalent examination. However, since he had not studied Sanskrit in SSLC examination, which he had never passed, the selectee was not holding the selectee could not be said to be holding the requisite qualifications. Paragraph. It was submitted by learned advocate, the appellant, that when what was required was that the candidate should have studied Sanskrit language in SSLC, non-passing of SSLC ought to be considered as debility on part of the respondent 3. And on that score, he could not have been selected. Paragraph. The submission is misconceived. At full stop. Admittedly, the passing of Kavya and Sahitya examination has been treated to be examination equivalent to SSLC. Full stop. When this equivalent passing was possessed by the third respondent, the question of his passing SSLC examination separately would not have arisen. Full stop. Holding the qualification of Kavya Sahitya, qualification of passing the Kavya Sahitya examination has to be treated as passing the SSLC examination itself, since both are treated to be equivalent as per the aforementioned notification. Full stop. Furthermore, there is no dispute about the fact that in passing the Kavya Sahitya examination, respondent 3 studied the Sanskrit language. It logically suggests that the third respondent studied Sanskrit in the SSLC examination itself, since the equivalent examination was passed. Full stop. It is to be noticed that the recognition of equivalent examination, which was Kavya Sahitya examination, was intended to give encouragement for studies in the Sanskrit language. Full stop. It is for the said, it is on the said rationale that the passing of said recently that the Kavya Sahitya examination is treated as SSLC examination. Therefore, the candidate had necessarily studied Sanskrit in the said examination. Full stop. The third respondent paragraph was found to be eligible on all these scores in terms of the eligibility prescribed in the recruitment notification. Paragraph. Learn a single judge has rightly reasoned, has rightly noticed the said aspect to reason as under in paragraph 9. Then page 30, paragraph 9, perusal of the above qualification up to respondent university. It ends in page 31. In the aforesaid view, in the aforesaid view, respondent 3 was qualified to be appointed for the post of telephone operator, having passed the certificate of equivalent examination of Kavya and Sahitya in Sanskrit subject itself. Full stop. The appointment could not be faulted from any standpoint. The judgment and order of law in a single judge is eminently just, proper, and legal. No interference is warranted. Paragraph D. Present appeal is dismissed. This is clear. Full stop. Is to be noticed that in the petition, the petitioner has not alleged any mala fide or bias against the selection committee. Full stop. As held in Jaswinder Singh versus State of Jammu and Kashmir, 2003 to SCC 132. In absence of any specific allegations of mala fides or bias, the challenge would necessarily fail when the selectee is found to have possessed the requisite qualifications.
Number 35, Vinod Kumar M.
My lord, complainant was allotted PDA site in the year 2004, my lord. Thereafter, my lord, in the 2019, my lord, the respondent, my lord, the deputy commissioner passed an order making over the very same land to BBMP for burial ground, my lord. My lord, challenging the said order, I filed a writ petition wherein this honorable court, your lordship, my lord,
Where are the directions?
my lord, your lordship, the order is in
Interim order.
my lord,
Interim.
interim order, my lord.
To take up with the.
My lord, if it is the case, my lord, direction to the single judge, dispose of the writ petition. The short question pending with further. This is a short.
As the order brought under the contempt jurisdiction is interim order. By very nature of the order, it doesn't determine the rights of the parties finally. And since the current proceedings are at large before a single judge to be decided on merits, the court is not inclined to exercise the contempt jurisdiction. Therefore, only on the ground that the order brought under contempt is interim order, these proceedings are not entertained. Accordingly, they are disposed of. Full stop. It will be open for the complainant to
Direction
raise
to-
all the contentions which may be available in accordance with law before a single judge.
Direction to
Of his
dispose of
rights and remedies
My
in
lord,
accordance with law.
a direction to dispose of the writ petition within 1 month.
Contempt jurisdiction, it will be
Because
open for the
this is a short matter. my
applicant to
lord.
request learn a single judge.
No,
to
yes.
dispose of the petition expeditiously, which may be received by learn a single judge, having regard to the calendar of roster, calendar of matters before him.
36 urgents, number 37. PC Sunita.
I appeared for the petitioner, my lord. Lord, the appellant has filed an challenging the order of the single judge, my lord. Earlier, my lord, appellant has filed a petition before the tribunal, my lord, stating that he is a permanent employee in the 7th respondent institutions, my lord. And he is an
You are temporary employee.
my lord, I have filed under 94 itself, my lord.
This
Before-
section, subsection shall not apply to the temporary employee.
Learned judge, my lord, has ruled that the dismissal of the section.
So learned single just says that the tribunal did not have the jurisdiction to entertain your.
It has a jurisdiction, my lord, oral termination, my lord. It is an oral termination. That's 94, it has got a jurisdiction.
Section 92 proviso.
Proviso is for the temporary employee, my lord. It's for temporary employee.
Or learned derogation, so and so notice written.
Please, please. It's not for stay, my lord. Stay of the order, my lord.
Court
Since
stay.
reinstatement, in earlier, my lord, tribunal has passed a reinstatement of the appellant, my lord, that was set aside by this learned single judge.
My lord, I take notice for 2 to 5.
So what is set aside by learned single judge?
My lord, tribunal has passed an order, my lord, for reinstatement of the
So then where is the
appellant.
question of granting any stay? What stay you are seeking?
The reinstatement, my lord, has.
Let
been
notice
passed.
go in.
Please, my lord.
EGF.
Learned addition.
Two to-
Below
2 to 5. 2 to 5.
Accept the notice. So it will go to 28th of May.
Please, my lord, please.
Number 38. Janata.
My lord,
Refer
these
the
are
appellant, my lords.
similar to the matters WA 210 of 23 posted on 2nd of April.
To be listed on 2nd of April along with similar matters. If number is available.
210. Number 39.
39 appear for the
Abubakar
complainant,
Shafiq.
my lord. Here, my lord. The order passed by the learned single judge at annexure L, my lord. It has not been complied. The order passed on 16/1/2023. So far, the accused has not complied, my lord, negligently, deliberately for the last 1 year.
Or learned educate. Yeah. For the complainant notice.
I accept for R3.
Returnable on 25th April. Learned government advocate Mr. Mahendra accepts the notice. On
For
behalf
R3.
of, on behalf of R3.
40 urgents, number 41. Mr. Gopala Krishna Swami.
Appellant.
Murthy.
Madam Lord, and for the appellant. That the appellant is before your lordship challenging the learned single judge order. Sorry, please. Challenging the learned single judge order on the ground that, my lord, there is a specific report submitted by the inspection of the respondent number 3, saying that, my lord, the respondent number 5 herein on 3/1/2008 itself, my lord, he has submitted application for availing a loan, but the sale confirmation has been granted in the name of the respondent number 5 herein on 13/2008, and there is a clear report submitted by the inspector of registrar saying that there is a clear collision between respondent number 3 to 5. So that is the observation, my lord, but that has not been considered, my lord. And my lord, without the issuing any notice to me, my house has been demolished. Though the tenants were very much residing in my house, my lord. I have produced the photographs also. That report your lordship will get at page number 157 annexure.
Statutory arbitrator
Yes, ma'am.
and statutory tribunal,
Yes, ma'am.
both are held against you.
Correct, ma'am. But
How
my lord,
this appeal is maintainable?
thereafter, my-
227.
my lord, thereafter, my lord, the learned single judge was pleased to dispose of the matter, remanding the matter to the again the registrar, my lord. Wherein, my lord, the registrar has given a clear finding that, my lord, they have colluded with the respondent number 3 to 5, and my appeal was allowed, and rupees 8 lakhs compensation has been awarded in the name of the appellant, my lord. And there is a clear report by the inspector of the registrar saying that, my lord, because, my lord, the sale confirmation itself is on 13/2/2008. Question of availing a loan on 3/1/2008 does not arise, my lord. Kindly come to page number 157, my lord.
You had applied for OTS also.
Yes, my lord.
Then everything, all the other things go away.
That has not been granted, my lord.
Correct.
Saying that,
OTS is on the premise that you are the debtor
yes, ma'am.
and debt is so much.
Correct.
And debt is outstanding.
But, my lord, as per the order of the learned single judge, my lord,
Arbitrator, yes, yes. Arbitrator awarded the amount.
Yes, ma'am.
Tribunal confirmed it.
Permanent single judge also.
Now, even if everything
but thereafter, my
is
lord,
from you,
my lord,
we
thereafter, my
can't
lord, thereafter, my lord,
interfere in this concurrent.
thereafter, my lord,
And therefore, this 220 is essentially purely 227.
my lord, thereafter, my lord, my lord, I approached this court before the learned single judge, my lord. There is a condition order. I have to deposit 1,40,000, my lord. I have deposited also, my lord, that amount. I have deposited, my lord. I have
Tamanna
deposited.
judgment, covered by Tamanna judgment. If
Please,
you have preferred a writ petition
please,
employing 226 and 227
please,
against order of an authority in admitted jurisdiction,
please.
it's a section 70 order.
Correct.
Then the petition will be 227 only,
Please,
number one.
please.
If petition is 227, no intra-court appeal.
Correct, my lord. As per the
My lord,
larger
seventh judge.
judgment, my lord. But, my lord, thereafter, my lord, the petition was disposed of by remanding the matter. Wherein, my lord, it was found that by appeal was allowed. And rupees 8 lakhs compensation was ordered because it is illegal demolition.
This intra-court appeal filed under section 4 of the Karnataka High Court Act 1961 calls in question learned single judge's order dated so and so, whereby petitioner's WP number so and so came to be negatived on so and so. First off, what was challenged in the writ petition was the order of the Karnataka Appellate Tribunal dated so and so, entered in appeal number so and so, whereby the award passed by the statutory arbitrator under section 70 of the Karnataka Cooperative Societies Act was affirmed. First off. Next paragraph. Learned counsel for the petition appellant vehemently argues that both the arbitrator and the appellate tribunal have grossly erred in not considering several contentions in their right perspective, and therefore there is an error apparent on their face. And as a result, the interference of this court is eminently warranted. First off. Next paragraph. Having heard the learned counsel for the appellant and having perused the appeal papers and also having heard the learned AGA appearing for the official respondents, we decline indulgence in the matter in as much as where the challenge in the WP is of an authority passed in admitted jurisdiction, such challenges are to be treated as falling essentially under Article 227 of the Constitution, the other provision, namely Article 226, having been ornamentally employed in the pleadings. First off, this view gains support from the 7-bench judgment of this court in Tamanna versus so and so, ILR 2000, so and so, so and so. First off, since the appeal, the intra-court appeal is itself not maintainable, the questions of considering the merits thereof would not arise. First, in view of the above, the appeal being devoid of merits is dismissed. rejected in limine. First off, registry to send a copy of this order to the private respondents. By speed post immediately.
Great.
Right.
42 urgent, number 43, Mr. L. Srinivas Babu.
Lord, this is also similar to
For
WA
appellant,
210
my
of
lordship.
23, my
For
lord.
appellant.
Response,
The case is with regards to the
Also
PTCL
same.
land.
2nd of April, my lord.
To be listed on 2nd of April.
Yes.
Along with.
Yes, lordship.
Number 44, Srimati Shilpa Rani.
Against the interim order.
I appear for the complainant, my lords.
Against the interim order.
My lords, complainant advocate on record has asked me to take the pass over, my lords.
Covered by the judgment. Why unnecessary? Faculty. This complaint alleges violation of interim order dated 12/7/2023 made by a learned single judge of this court in a pending case in WP number 13379/2023. Full stop. Learned AGA appearing for the second respondent herein at the outset points out that ordinarily complaints of the kind are not entertained by this court. Wide debate judgment dated so and so, so and so. First off, in view of the above, this complaint of contempt is disposed of, reserving liberty to the petitioner to work out his remedy before the learned single judge if grounds do exist therefore. First off.
This is number 45, Mr. Suraj Nayak.
It's for the appellants in this matter. My lords, the writ petition was filed by the petitioner, my lords, challenging the order of dismiss from removal of service, my lords. My lords, briefly the facts, my lords, I might request my lords to kindly turn to page number 20, my lords, which is the order of the learned single judge.
So what was the petition by your brother?
My lords, the brother had also filed a petition for removal of service, my lords.
Removal of?
From removal of service.
For?
My lords, the Konkan Railway.
He was also wanting to be appointed.
Please, my lords, there was a condition stipulated by at the time of recruitment, my lords, that only one person from the land loser,
Family.
one son of the land loser would be considered for appointment, my lords. And both the brothers had filed
But then one of the brother gave up the appointment.
Please, my lords.
Forgone the appointment.
My lords, that is after the learned single judge took into consideration the affidavit filed by the delinquent employee.
Then the present respondent will be your beneficiary.
Because the learned single judge has allowed one of the writ petitions and dismissed the other writ petition based on an affidavit filed by the brother, my lords. That affidavit was not served upon us, my lords.
No.
That affidavit was not served upon us.
That's all right. Now, it's the policy of the state that where you take the land of a citizen, the amount which you are giving by of compensation is not that attractive. Therefore, you have made a policy that one person from your family would be employed in our establishment. What is wrong with this order?
My lords, the order of dismissal was based on the fact that both of them had colluded and misrepresented, which was unbecoming of a public.
How long first brother was employed for how long?
My lords, both of them have applied under the same notification and were appointed at the same time, my lords. And they were both employed for a period of 14 years.
14 years?
Prior to dismissal.
They were in employment for 14 years?
They were in employment for 14 years. They have
Now
taken away
to...
the opportunity of another person being gainfully employed while being employed, due to their misrepresentation.
But one is allowed, one is dismissed. Now that cause is served now.
Well,
at least to one you have to give, na?
Well, it's our case is that the Honorable Learned Single Judge has gone beyond the scope of what the law has been laid on in respect of judicial review. The conclusion has been the Learned Single Judge. It was not even the case of the petitioner that one of the brothers have to be given employment and the other person has not. There's no pleadings in that.
It's your version only.
Please.
It's your version.
No, madam. That is what the Learned Single Judge.
Do you deny that? You can't deny because there are papers. which provide,
Please.
these are all kind of compensatory appointments for losing the land.
Please.
Land is held very dearly.
My lord, but the learned single judge has not considered several bar objections and also.
Justice, overall justice is.
My lord, there is a judgment in the case of Praveen Kumar, my lords, in a similar circumstance. The honorable court has held that the court cannot go beyond.
That's all right. That's all. But
Yes.
now we have to show
Please.
not only order is wrong, but order is unsustainable. Wrong, perhaps arguably you have shown to us now.
Please.
But unsustainability is not shown. Mere it is wrong is not, will not give you right of appeal.
My lords, I may request my lords to kindly turn to page number 24, my lords. Paragraph number 14. I'll just read a few paragraphs. In light of this clear stipulation that only one son or one unmarried daughter of the landlord would be eligible in respect of a land lost for acquisition, it is obvious that only one of the petitioners would be entitled for securing employment. Merely because the petitioners lost more than one piece of land, that would not give them a right to seek multiple. It is only given to only one.
One only.
My lords, but the other person by way of misrepresentation was employed for 14 years. That has to be considered.
Third learned advocate, Mr.
Suraj Naik. Suraj Naik.
Suraj
Naik.
Naik for the appellant. Two writ petitions came to be disposed of by a single judge as per his common judgment and order dated 20th September 23. Out of the two, writ petition number 16536 of 14 was filed by one B. Ashwar, whereas the other writ petition was filed by one B. Ravindra, who was the younger brother of the other petitioner. The grievance of both of them was that the order of removal of from service was passed against them. Paragraph noticing the facts in the background, comma, the two petitioners were the sons of one Krishnaya, their father, who held the lands bearing survey number 66/9 and 79/2B, situated at Bayandor, Kundapur Taluk. The land was acquired by the Konkan Railway Corporation Limited. The said Krishnaya accordingly lost the land, which was the source of livelihood. Paragraph. The Konkan Railway evolved a policy to provide job to the land losers, and notification was issued in that regard to recruit on the post of gangman exclusively from the candidates who were the members of the land loser family. Both the petitioners above applied pursuant to the notification which was issued in the year 1996, seeking recruitment to the post. Paragraph. The railway authorities noticed that in respect of one land loser, Krishnaya, two sons had applied, which was perceived by the railways as commission of misconduct. Full stop. The action was initiated against both the applicants, and they both came to be removed from service after undertaking an inquiry. A single judge disposed of the petitions by observing that one of the brother Ashwar, the petitioner of SCNM, petitioner of writ petition number 16536 of 14, had foregone his claim for appointment. A single judge therefore took view that the other son would become entitled to get the appointment on the ground that he belonged to the land loser's family as the son of Krishnaya. Paragraph. Only submission which could be made by learned advocate of the appellant was that in the policy there was a clear stipulation that only one son or unmarried daughter of the land loser would be eligible to get the appointment. He submitted that two sons had applied. Therefore, none would be liable to be given the land as land losers because they tried to seek double advantage of the policy. It was contended that merely because the petitioners lost more than one piece of land, they would not give them right to seek multiple appointments. Full stop. When one of the brother has given up his claim to the appointment, by necessary implication, the other son would become entitled to be given the appointment on the ground that he was from land loser family. Full stop. In clearing the appointment for said Ravindra, the petitioner of petition number so and so, alone a single judge has only furthered the object of the policy of compensating the land loser with an appointment to one of the member of the family. Full stop. The hyper technical stand on part of the appellant railways that two sons had applied, therefore none would get the appointment, would not be accepted, more particularly when one of the son has foregone the right to be appointed. Full stop. What the judgment and order and the directions contained therein of a single judge has done is to redeem the substantial justice. So no interference called for. In the
one submission on the last
writ
aspect,
appeal.
Lords, on the aspect
The
of
appeal is meritless and stand dismissed.
Lords, on the aspect of the employee giving an affidavit foregoing the appointment, Lords, the corporation may be permitted to decide who to retain in the employment.
Who to retain? He retained. Ravindra has retained him. Because other has given up. So simple. 1 + 1 or 1, 2 - 1.
This number 46, Mr. Jain Dev Kumar.
For the appellant in the first three matters, my lords. May I seek some accommodation, my lords? There's a bereavement in the advocate's family.
My submission,
Beyond vacation
Um,
or this side.
my submission
Let
is
me
this,
please-
my lord. This matter relates to an educational institution which belongs to the publics. A person is treating it as his private property and is creating all kind of problems.
My lords have heard the.
No meeting, no annual general body was conducted for a period of 14 years. The status quo order passed by this honorable court was opposed by me on 9/1/24, my lord. Your lordship may kindly see the order. By way of interim order, the parties are directed to maintain status quo as on today. The parties are put to notice that on the next date of hearing, if it is convenient to court, the appeal shall be heard and disposed of on that day only. It was passed on 9/1/24, my lord. Till today, 7 hearing dates, almost 6 hearing dates, my lord. On one way or the other, they are taking adjournment. First, they said it is not served.
The matters had to be
The
connected.
Still
strength
give
of,
some accommodation.
it was kindly posted on 23rd, my lord.
23rd of
First week or
May.
second week of April.
25th of this month. The college student, my lord, the capacity of the strength of the students from 1,600 has come down to 1,300. There is severe misappropriation.
Some
Who-
inquiry will put up immediately on reopen.
Please.
7th May, 7th May.
No. My submission is first week of April, May. First week of April, May.
28th.
Well, the admissions will start, my lord,
From?
to the college
When?
From which day?
from April, May. The students from 1,600, it has come down to 300. The college is on the verge of closing.
The matter pertains to a society not registered under the Karnataka Society Registration Act. The allegations which he is making with respect to misconduct or any maladministration pertaining to an education institution, my lord, will not have any bearing in
Bearing
this.
on them.
My lord, it is
But
the,
it runs the institution.
it is the
Society
governing
runs the
body
institution.
that runs the institutions, my lord. That is the
Anyway,
first week
immediately
of,
after vacation.
first week of April, May. First week of April.
We will not.
Third week of April.
Please,
23rd April.
please.
Great.
Number 47, Mr. Keshu Bhatia.
For appellant, my lord, kindly pass on, my lord. Ready.
My lord, this is with regard to the last time, my lord, the learned.
Lord, on the last date, my lords were pleased.
They have granted. Government has granted. There is no dispute. It has become final also.
If there is a change of law subsequent to the decision of the tribunal, then the law in vogue will apply. That's a simple thing.
But Allah, that has become final, my lord. The earlier grant has become final. Kindly see, my lord, what has happened. But kindly see, my lord, the annexure A. Annexure A is the grant. My lord, typed page is, my lord, English translation is at page 21. 21. On the third paragraph there, what? On the basis of the report of the Assistant Commissioner Puttur, since the tenancy land conditions are fulfilled in 5.29 acres of tenancy land in survey number 308/3, by stipulating the present market rate of rupees 12,000 per acre, as directed in the government order number so and so dated so and so, it is granted in favor of Saint Anthony Church by way of permanent.
Have you paid the price?
Pardon?
Have you paid the price?
But we challenged this condition to pay the price. My lord, kindly see the order passed by the KAT.
So grant becomes complete when you perform your part.
That is right. That is right, man. That is right. But kindly see what the tribunal has, page 27. 1 second. Last paragraph. Page, the order of the KAT. In page 27, last. In the result, the appeal is allowed. The impugned order passed by respondent relating only to the amount fixed and payable in respect of the land in question is set aside. It is only with respect to the amount set aside, and the matter is remanded to respondent with further direction to determine the payment of such amount at the rate of rupees 200 times of the land revenue payable in respect of the land in question and thereafter. Therefore, I am saying, my lord, let them determine and.
What is the change of law now?
Now, my lord, you can fresh make apply. Now, my lord, as per the law, now, my lord, the.
Where is the law? Which is that law?
Rule 23A of the Karnataka land grant.
Karnataka land grant.
How it covers, does it comprehend the accomplished transactions?
Now, the market rate, my lord, the.
Please read the rule, change of law. How law is structured? Does it comprehend the accomplished transactions or transactions which are halfway through? Or will they allow reopening of the transactions? That you have to answer.
But I will. place that for some short accommodation. They are running educational institutions. But a college is there.
Following shall be substituted. Substitution operates from the date ab inceptio.
22 years to substitute.
But it says rule.
Ordinarily,
It is 22A or 23A?
23.
23A.
23A, man. Can I just read it, man? 23A.
I have read that now. The legislature in its wisdom has employed the word substituted.
But it has got only a prospective murder substitute.
Substitution. We have taken that literature from Justice Felix Frankfurter of American Supreme Court, a great judge. He said, where the legislature employs the word substituted, ordinarily that will be with retrospective effect, unless there is an indication otherwise by the other text of the provisions. This is how Maxwell on interpretation, Crace and statute, Sutherland on interpretation, they go.
But this is not legislation at all, but substitute.
You have to, this is how we understand, this is how GP Singh of our Indian, the author, you have seen that.
Madam, presupposition is, my lord, they are actually a college, institutions are there. Say church.
That means unless the law differentiates the ratepayer on the basis of status, you can't put forth that argument. It only plainly says, these rates were there. Now, law substitute is substituted by way of amendment.
But can I?
You only have argued one matter before me when I was sitting in single, where you said, because the law has employed the word substituted, it should be with retrospect. We agreed with you.
Today, my lord, they said they will come back with some instruction. That's why, my lord, can I come back, my lord, next week? To persuade your lordship. I'm sorry, man.
Unless law is again changed.
I'm sorry, man.
We are not going to change it. That
I
is
will not
certain.
request
I
for
change
that.
your submission, your argument, your stand, whatever. Monday, this is all in lighter vein, don't take it as.
Wednesday.
Wednesday, Wednesday. So we'll be listing this on the, first on the board. Wednesday, so that it is, we recollect it when we are fresh. Otherwise,
no.
Memory is fade.
So to be listed on the board, top of the board. On Wednesday. Thank you.
Number 48, Stage B Mukanapa.
The appellant in this case. My lord, the appellant, he was a driver. When he was working.
So 7 years delay in approaching the.
Yes, my lord. My lord, according to labor code, according to corporation, my lord, the 7 years. My lord, according to me, my lord, the 5 years delay, my lord. Because my lord, the earlier after passing the punishment order, my lord, the appellant
10 for reference.
Yes, my lord. He raised the dispute. Writ petition is allowed, filed by the corporation, only on ground that delay and latches. The
5 years.
5 years delay. Well,
5 or 7, whatever.
No, assuming it is 5 years. Our budgetary system is on periodic elements. Every 5 years, we change the government. And that is the reason why most of the financial institutions have that period. One fine day, if you come and press your claim, where from the money should be raised?
My lord, the point of reference, my lord, at any time, my lord, the workman has raised the dispute, my lord, the limitation act is, my lord, is not strictly applicable to in the labor law, my lord. My lord,
So the workman, if he was removed when Babar had come or Alexander had come here, and if he was removed then, still he can raise the issue, is your version.
my lord, the limited period, my lord, the not inordinate delay, my lord, the Honorable Supreme Court, my lord, saying that, my lord, the kindly permit me to produce the judgment passed, the apex court, my lord. My lord, in merits, my lord, the charge not proved in the labor court also, my lord. And also the inquiry officer also, my lord, the given the finding, the charge not proved. Moreover, my lord, the after passing the punishment order, my lord, the workman has filed the appeal before the before the appellate authority in the corporation in 2005. The appeal also is rejected, man. Thereafter, he raised the dispute before the conciliation officer, my lord. And then, my lord, the 2010, my lord, the point of reference is referred to court for
This way, that way. Law is very. Law in the field is like a chancellor's foot, from 9 inches to 13 inches now. All kinds of judgments are there. The one which you are now citing, which is that judgment?
my lord, the can you permit me to melody and 2003-4 SCC and 27 SM Nilajkar and others versus Telecom District and Manager Karnataka. Melody para number 17, melody. Melody para number 17.
First judgment.
First judgment, melody. 2003 volume 4 SCC 27, melody. The para number 17, melody. It is submitted on behalf of the respondent that on account of delay in raising the dispute by the appellants, the High Court was justified in denying the reliefs of the appellants. We cannot agree. It is true, as held in Shalimar Works Limited versus Workman, that merely because the Industrial Dispute Act does not provide for a limitation for raising the dispute, it does not mean that the dispute can be raised at any time and without regard to the delay and an industrial tribunal. Even so, it is only reasonable that the dispute should be referred as soon as possible after they.
This paragraph goes against you.
Well, kindly permit to another 2 lines. Have arisen and after conciliation proceedings have failed. Particularly so when disputes relate to discharge of workman wholesale, a delay of 4 years in raising the dispute after even re-employment of most of the old workmen was held to be fatal. Shalimar work.
4 years delay was held to be fatal.
Here, 5 years delay, in all Supreme Court judgments, the delay in at any time of occurring, the section.
What is your case in the writ petition about delay? Or before the even?
The corporation has filed the writ petition.
Before the labor court, what was the case about delay?
The labor court, the labor court award, the annexure F.
Where is your claim petition?
Statement of claim, yes.
Claim petition is not filed by the corporation because this writ petition is filed.
You have your claim petition with you.
The earlier call for records.
No, even assuming you are 5, there is delay of 5 years.
Yes.
The limitation is not prescribed by the legislature for working out your remedy is one thing. But courts will decline indulgence where the person litigant is sleepy and tardy. This is what Jeremy Bentham said long ago.
Obviously,
many jurisdictions operate with this premise.
Obviously, the workman has pleaded regarding the delay because of financial difficulties and the not aware of the law. So many point of reference is
the main aspect.
How appeal is maintainable? It was within the admitted jurisdiction. Admitted jurisdiction of the labor court, which had granted you relief. Learned single judge said it not. The 7-judge bench says that ordinarily no appeal at all, unless it falls into one of the three extraordinary grounds, which arguably they are absent.
The only, the honorable learned single only, my lord, rejected only on ground of my lord.
Third learned advocate, Mr. What is your good name?
Naveen Kumar.
This is serial number?
Naveen.
48.
48. 16, read appeal 1615 of 23, third learned advocate, Mr. Mukanappa.
Yes, ma'am. This is my
For
senior.
the appellant and learner, anybody else appears? And learned additional government advocate, Ms. Nilofer. No, corporation, you are not.
No, my lord.
By the
So only-
KSRTC corporation.
Only
my lord.
learned advocate, the appellant. Full stop. This writ appeal under section 4 of the Karnataka High Court Act 1961 is directed against judgment and order dated 24th November 23 of learner single judge, whereby the petition filed by the Karnataka State Road Transport Corporation was allowed. In turn, the judgment and award dated 11/4/14 of the Industrial Tribunal Mysuru in reference number 181 of 2010 came to be set aside. Full stop. Noticing the prayer in the writ petition at the outset, what was prayed was to issue the writ of certiorari to quash the award of the Industrial Tribunal. The facts in the background paragraph was that the respondent was a driver working under the appellant corporation, while on duty in a bus flying between Bengaluru to Saravana Belgoda. Caused accident which resulted into death of the pedestrian. Upon inquiry, the inquiry officer imposed the punishment of what was the punishment?
My lord, the reducing the basic pay is the 5 annual increment with cumulative effect.
5. He was reduced in the basic pay by 5 incremental stages with cumulative effect. Full stop. The Industrial Tribunal, when approached by the workman, passed the judgment and award to set aside the said punishment, directing the restoration of the increments. However, denied the benefit of interim period of 6 years. Full stop. While setting aside the paragraph, learned advocate learned appellant raised various learned advocate for the appellant workman raised various submissions to submit that the judgment and award of the Industrial Tribunal was proper in the facts of the case, and that learned single judge committed an error in allowing the petition, setting aside the judgment and award. Paragraph. At the outset, the court notices that what was under challenge in the writ petition was the judgment and award of the labor court. Writ of certiorari was prayed for. Full stop. In that view, the petition filed by the corporation was under Article 227 of the Constitution only, neither in the prayer nor in the pleading or even in the judgment and order of learned single judge impugned in the appeal. Any aspect of element of exercise of jurisdiction under Article 26 could be noticed. Full stop. It was a pure petition resulting into the judgment and order of learned single judge under Article 227 of the Constitution. In that view, the law laid down by this court in the Tamanna versus so and so would operate to render the very appeal to be not maintainable, since it arose from the proceedings under Article 227 of the Constitution only. Even otherwise, the court has examined the merits of the case. Learned single judge, what weighed with the learned single judge was that the workmen had approached the private industrial tribunal after yawning gap of 5 years, which 5 years from the date of order of punishment. Full stop. The dispute had become stale after passage of 5 years. 5 years. Full stop. The decision of Prabhakar was decision of Supreme Court in Prabhakar versus Joint Director, Sericulture Department, and another into bracket 2015, 15 SCC 1. Settled the law that the delay and laches would render the proceedings of reference not maintainable since the industrial dispute would become stale. Full stop. No error was committed by a single judge in placing reliance on Prabhakar Supra and allowing the appeal to dismiss the judgment to set aside the judgment and award of the industrial tribunal. Full stop. Learned advocate sought to rely on the decision of the Supreme Court in SM Nilajkar versus Telecom District Mahanagar Manager, Karnataka, into 2003-4 SCC 27, to submit that it is not the rule of thumb that on the ground of delay, the reference could not be maintained. So sought to be submitted that the aspect of delay may be may weigh on the count of maintainability of the proceedings, depending upon the facts and circumstances of each case. He relied on paragraph 7 on the decision in SM Nilajkar Supra to highlight the to buttress his submission. When the observations by the Supreme Court in SM Nilajkar Supra, more particularly in paragraph 17 of the judgment relied on by learned petitioner are closely read, comma. It rather supports the view taken by learned single judge. It is provided that even though there is no limitation is prescribed for raising the reference of disputes before the industrial tribunal, comma, that would not mean that the workman can invoke the jurisdiction of the labor court at any point of time, irrespective of the delay and laches. Delay and laches, comma, it was held, always operate as relevant factors in maintainability of the reference. Full stop. In Shalimar Works versus Workmen, Shalimar Works Limited versus Workmen, MEN, into bracket AIR 1959 SC 1217, even the delay of 4 years in raising the industrial dispute was held to be fatal. Full stop. Thus, none of the submissions canvassed by learned appellant could be countenanced. The judgment and order of learned single judge allowing the appeal and dismissing the and setting aside the judgment and order of the industrial tribunal is eminently just proper and legal. No interference is warranted. The writ appeal is dismissed.
Number 49, to Gautam ER.
49 pertains to filling up of the vacancy of Upalokaikta. For last 2 years, my lord, it is my lord, I'm permitted to make one submission.
Vacancy of
The file has traveled, there was some hurdle because the opposition leaders not appointed in the upper house. Then there was a delay. Then, my lord, again, the lower house, my lord, they waited for the appointment of the opposition leader. Now the file has traveled. I think the file has traveled to The Chief Justice has a consultee under the Act. That appears to be the latest position. For what has happened is this, that 60% of the mandamus which we are seeking before the High Court can be resolved in the Lokayukta. This is my personal opinion. By mere direction by the Lokayukta, they are also doing this inquisitorial function now. Therefore, it is more effective in Karnataka, especially. There is one justice who is functioning as the Upalokayukta, is traveling all over the state. Therefore, for the last 2 years, it is vacant. It will be very effective institution if another Lokayukta, who is already sanctioned by the government, is appointed. I cannot say more than that because the file is.
Nobody is averse to not appointing the Lokayukta. So we'll take this one. Everybody wants the appointment. Is it correct? Let us wait.
But the state government, is ready, provided.
We'll see. 2 weeks, 3 weeks.
My lord wants me to file the statement.
No, I think I did not.
The stage and the process and etc.
But I think I did not make myself clear.
How do you know that things have moved?
Pardon
When
me?
government advocate doesn't.
No. They have already, my instructions, but I had a discussion. They have already cleared. Ultimately, it has come.
We'll thresh out these, but let.
Yes, ma'am. Yes.
Whenever you want.
2 weeks.
2 weeks. We'll keep it on 23rd of April.
Number 50.
I appear for the petitioners in this case, my lord. There is a case pertaining to the issuance of false and fake caste certificates throughout the state of Karnataka, my lord. By notification in the official gazette, some of the subcommittees were included within the main caste of Nayakda, my lord. These subcommittees are Talavaras and Parivaras, my lord. Now, there are Talavaras and Parivaras in other OBC castes as well, and also other castes which are not coming within the bracket of ST, my lord.
Then the committee for the.
Yes, my lord.
Committee will examine. in
Lord,
light of
what
Madhuri
happened?
Kartik.
I appear for the respondent. What happened, my lord, with regard to the first prayer? It will not be survive in this writ petition because kind is turned to my lord Annexure K.
You appear for whom?
I am for this special counsel. I have been appointed to deal these cases. Annexure K may be kindly seen, Lord.
Annexure K, which page?
In page 82, according to my paper which they have been furnished to me. Typed this thing is there. We have issued a direction to all the authorities, keeping in mind the Karnataka Scheduled Caste, Scheduled Tribe, other backward classes Appointment Act and rules, and also law laid down in Anand case. Strictly they have to follow while issuing the caste certificate to the person. And not to the person, there are 2 castes. My learned friend did not canvass that. There are 2 castes goes by a same spelling. One is Parivara, which is a synonymous to Beda. Another Parivara, which is a synonymous to Besta. Similarly, Talvara also. We have said, my lord, while issuing the certificate, may I read, my lord?
Page number?
Page number 82, typed copy is there. Even my writ petition is also not that so properly numbered, which have been fun.
2, 3
My
numbers
lord,
are
it was
given.
numbered based on the translations. I
Annexure
think
K may
you-
be kindly seen.
Numbering is also substandard.
They have applied reservation. Issuance of caste certificate, lordships got it, well?
Yeah.
Circular.
31/8/20.
Yes.
Yes, my lord. There, last paragraph may be kindly seen, my lord. Annexure B, para B. As per the direction of the Supreme Court, your lordship got it, my lord? As per the direction of the Honorable Supreme Court, direction to the Karnataka Scheduled Caste, Scheduled Tribe, other backward classes appointment notification 90, rules 19. Tahsildar, who is authorized to issue caste certificate, ought to compulsorily follow the mandate procedure while issuing the caste certificate. See, Lord, the authorities are officially issuing the caste certificate as the complete responsibility to ascertain the genuineness of the claim of the appellant for issuance of a caste certificate before issuing the caste certificate. The Talavara and Parivara caste, which are also present in the backward class list, for a persons belong to these caste, there is no provision to issue caste certificate to persons. We have said so. The second prayer is, my lord, please.
Now, the internet instructions to follow the procedure. Laviti
Yes, Levitigiri. Milan, lot of judgments has come.
The caste certificate is for appointment. Then prescribes validity certificate. It should be validated by a district level committee, by the deputy commissioner. Unless that is validated, this is the scheme of the act.
That as per
For some castes, whose they spell same way.
yes.
The problem arises. Spell same way. One such caste was earlier.
Moger,
Huh?
Moger.
Moger.
Moger and Maleru.
Maleru. There is one Brahmin sect which also claimed that it is also scheduled caste.
Scheduled tribe.
Tribe, scheduled. Matter when Congress court said we should follow this.
Supreme Court.
This is how caste law relating to caste in the state operates. Yes.
Supreme Court in Maleru case directed the National Commission to verify and to submit the report. Here, my lord, as for the first pair, for a moment, my lord, we lost to kindly turn to the pair sought in the writ petition.
For us, it is difficult to consider this.
That's what, that's
First prayer has already been complied. The second prayer is, they obtained a
My lord,
certificate.
first prayer is
Let
not
the-
complied, my lord. There are several caste certificates we have produced in this writ petition where there are
Lord,
double entries,
if
my
that
lord.
were to be so-
Initially, I'm an OBC, my lord. Suddenly, my caste changes. And the Tehsildar issues me a new certificate to the same person, very same name that is in the OBC caste certificate till yesterday. Today, the same person receives an ST certificate, my lord. So it is, first prayer is not complied, my lord. Which is why the need for this PIL, my lord. We have shown at least 100 caste certificates for the same name. It is a very same person with the same father's name, mother's name. The records are before this honorable court, my lord. The same person suddenly changes the caste, my lord, overnight.
The Deputy Commissioner is not arraigned as a party if the direction is sought.
How, these are all individual rights.
True.
By
My
issuance
lord-
of the certificate, you are so distant, you are so much distant to the court. We are not in a position to appreciate your argument at all, apart from merits.
My lord,
The
my
distance
lord,
between us is
today
too
there
long.
was, my lord,
No, they should have-
I'm very
submit, my lord.
obliged to
Deputy
come
Commissioner
before
should
this
have arraigned
honorable
as a
court and
party
make
in
the.
the writ petition.
Individual grievances.
They should have gone before under 4B. 4B, there is a provision to
Appeal
agitate.
to the assistant commissioner.
Assistant Commissioner. 4B,
My lord, this
4F.
is not-
They
this
can
is
make
not
a
an individual
representation to
right.
the Deputy Commissioner. Deputy Commissioner verify and annul the certificate.
I'm not pressing
Why
individual
they have
rights,
to
my
approach
lord.
this court?
They are the remedies under 1990 Act.
Yes, my lord.
My lord, 1990 Act is also violated here, my lord. That's
Madam, these
also my grounds
prayers,
in this
prayers
petition.
you are advancing in the public interest petition.
And they have not arraigned as a party here.
Two
They are affected. Should they not be heard in this manner? So many persons have obtained certificates.
My lord, on 15/9, this honorable court has passed orders, my lord.
Would
that
you
are-
prefer to argue? Would you prefer to argue by
We
coming
prefer
into
to
court
argue.
physically?
Yes, my lord. Today, there was some
Day after
personal
tomorrow.
inconvenience, which is why
Day after tomorrow.
day after tomorrow. Much obliged, my lord. Apologies for not being there present physically, my lord. Today, there was some inconvenience, my lord, personally.
Day after tomorrow at the top of the board?
Much obliged.
Yes.
Here, deputy is not made as a party. As my lord, they could have arraigned national.
It will be at 2:30, convey to the council. Yes.
Obliged, my lord.
Yes, 2:30, madam. Yes.
Number 51.
Appearing for petitioner, my lord. My lord, the fourth respondent, my lord, encroached the property reserved for the public purpose, my lord, reserved for Anganwadi purpose, my lord. In spite of our request by the petitioners, my lord, the third respondent, being owner and custodian of the property, simply issued a notice to the fourth respondent, my lord. However, the fourth respondent did not stop the construction, my lord. The third respondent themselves admitted that.
Man-
Similar matters, we have said that you should approach the Lokayukta.
Yes, yes, my lord. Last week, my lord.
Last week. Please. Approach that way. Do you want to withdraw or you have to make the order?
And order, please.
What do you want? Time?
No, sorry.
Order.
Please.
The petitioner herein by filing this petition, styling as public interest litigation, has prayed to require the respondent authorities to consider the representation made by the petitioners on 9/1/23. As also dated 1/4/23. They are the representations made to respondent 1, the Chief Executive Officer, Bellary Jilla Parishad Bellary, and respondent 2, the Executive Officer, Taluk Panchayat, Sanduru, SNDURU, Bellary District respectively. The grievance of the petitioner appears to be alleged encroachment on the government land at Baspura village, Sandur Taluk. Stated in nutshell, it is awarded in the petition inter alia that injunction suits came to be instituted by respondent 4 against private parties in respect of their occupation of the government property, which was dated to be reserved for the purpose of Anganwadi. The suits were dismissed. It is the allegation that despite that, respondent 4 started construction on the said government land. The objections raised by the public were not paid heed to by respondent 4, and the construction was not stopped. Paragraph detailing such facts, the aforesaid representations are made by the petitioner. Petitioner wants consideration of them at the end of authorities. Full stop. Full stop. The learned government advocate who appears for the respondent.
Lord, respondents
Below
3 and 4.
appear
Madam,
to
I'm
respondent
sorry.
said,
Respondent
submitted
number
that
4.
the very grievance, number 4,
Yes.
submitted that the very grievance in the prayer as it sought to be agitated in the present petition could be made before the authority of Lok Ayog under the Lok Ayog Act, Karnataka Lok Ayog Act. Of which year? 1984. Full stop. Since this remedy is available to the petitioner, the court does not see any good reason to entertain the present petition. Full stop. Paragraph. It is open to the petitioner to avail appropriate remedy in accordance with law, in respect of which, however, this court does not express any opinion on merits. The present proceedings are accordingly disposed of. It has not entered.
Right.
Number 52.
My lords, I appear for respondent number 8, my lords.
My lord, I appeal for respondent number 1 in this case.
In this matter, my lord. The petition, this matter, may be listed tomorrow, my lord.
Tomorrow?
Tomorrow, my lord.
Tomorrow will not be possible.
Any other date, my lord.
Thursday?
Yes, my lordship convenes.
What is it about?
My lords, this matter, my lords, an NGT order has been, that's firstly, my lords, apologize.
Will you all right if you list on Thursday or next week? When do you want?
Thursday, my lords.
Thursday?
Thursday, my lords.
It's
The short point, my lords, if Nabil can.
Lord, I represent the state environment in the impact assessment authority. There, if you have issued notice, Lord, they have to reply the first part. Second part, Lord, if you have kept Lord environmental clearance in abeyance.
On that day will consider.
That part can be stayed, Lord, not notice part. Let them reply, Lord, notice part.
On that day will consider.
On place. Grateful, my lord. My lord, may the interim order be extended?
It is operating.
Yes, yes, my lord.
Interim order already operating in the petition shall continue to operate till the next week.
Please.
So then let it go to next week. Next week. There is no urgency. Next Thursday. Next Wednesday.
Please.
Next Wednesday.
Number 53. Mr. P. Anand.
My lords, this matter, my lords, has been filed. I appear for the respondent pollution control board, my lords. It's a matter pertaining to environmental compensation.
Nobody is for petition.
P. Anand.
My lords may restrict on 27th because connected matters, my lords, if my lords may recall, that a batch of matters are coming for disposal, my lords, on the same point.
Along with that matter.
Yes, my lords. My lords, I just give the number. I'll give the number, my lords. Yes, my lords, I'll do that.
Know that to be listed with one.
Grateful, my lords.
Number 54. Mr. T.P. Muthana.
I appear for the appellant, my lord. This is the matter pertaining to the appointment on compassionate ground, my lord. This learned single judge, my lord, says that appointment on compassionate ground has to be given. Here, my lord, that this order of this learned single judge is basing on the order passed in the Karnataka Gramin Bank. Here, Karnataka Gramin Bank, what happened, my lord? Government has issued the scheme directly to them, government. But here, this nationalized bank, my lord, I am representing Canara Bank, my lord. Nationalized bank, the government has requested IBA, Indian Banks Association, to form a scheme. Here, this as per this scheme, my lord, they have that this has come into force in 2015. Up to 2005, my lord, there was no appointment. There was appointment on compensation ground. 2005, that appointment on compensation ground was replaced by payment of aggregation amount, and again it was introduced in 2015 by nationalized banks. But here, my lord, that this is effective from 5/8/2014. But this petitioner died in 2012. And this scheme, as per this scheme, my lord, this will operate from 2014. The person who dies after 2014, they are eligible for the appointment on compensation ground.
But scheme is with retrospective effect.
It is not there, my lord. It is not, as per the scheme of this bank, my lord, that entire scheme is not there, my lord. I think the scheme, your lordship,
You had not produced it before the learned single judge.
No, my lord, because it was not produced at all.
You are also party.
I was party. I was the respondent, my lord.
Then you should have produced as you are now producing before us. Therefore, whatever was argued based upon that, learned single judge gave the judgment. Had you produced it and drawn to his notice, which paragraph?
Paragraph, my lord, last page, Nami, paragraph 28 and 29, my lord. Page number, in the scheme, page number 10.
Whether the scheme applicable to Grameen Bank is different from
Different,
one
my lord.
applicable to.
Grameen Bank that the government has introduced in 2019. This nationalized bank that IBA has, as per the IBA has formulated scheme, and it was introduced in 2014. And 2015, that board has approved and issued a circular.
Different schemes there. Scheme itself is different. Different. Yes,
Third
notice.
learned educator, so notice written and belong. Reopening,
Yes, my lord, but interim order may give,
what is the interim order?
because that they may file the contempt petition, my lord. Is the next date of hearing.
28th of May. 29th of May. In the effects of the case till the next date, comma, the directions of learned single judge regarding consideration of the case of the respondent petitioner for compensatory appointment shall not operate.
Yes, ma'am.
Shall remain in abeyance.
Yes, please. Delay is there.
Delay is
Delay is there.
7 days delay is there. my lord.
then only.
Notice has to.
Respondent number 12 is before my lord as appellant. The property belonged to my vendor. My vendor's predecessor, they having acquired under a auction from the first respondent. Admittedly, there was an auction which was given by the first respondent temple, wherein the property was taken on perpetual lease and also on Chalagani term lease. And that on the basis of which they were in enjoyment of the property. Subsequently, 2004, there was a mutation in the name of my predecessor. Then there was a partition amongst my predecessor's family, from whom one of the shares I purchased.
That
After
was
a lapse of
3-1.
around 10 years,
Partition is dated 3/1/2000.
2007, my lords.
2007.
Please. Now, all these three mutations are challenged without filing a delay application.
This court has said it.
2018 Supreme Court.
No limitation.
So here no application for
No application for delay condonation is filed.
notice.
Please.
First week of.
Sought for interim order, stop a stay of the learned single
Any
judge.
directions are issued?
No, don't delay, madam. Within time.
My lord, I take notice for respondents 1 to 4.
What is to be stayed?
Please ask this order. There is change of ethics.
Change of entry.
Please.
Please ask to go to civil court. They should go to civil court.
So notice returnable on reopening.
29 May.
Please.
It is directed by of edit review that the status quo shall be maintained with regard to the entry question.
Oblige.
For 56, Manjunath H.
This
For the
matter, we
complaint-
have filed complaints affidavit on the last occasion.
For the complainant in this matter, my lords, at the last instance, my lords had sought for one clarification, my lords.
Complied with.
Compliance affidavit had been filed. So along with that, my lords were, my lords observed that it is lawful on their part. My lords, my submission would be in response to that is, my lords, in the impugned order, the direction was issued to all the respondents, but only one respondent filed the compliance affidavit. My lords, that is one thing. And apart from that, my lords, in this contempt petition also, notice to R2 to R5 has not been issued, my lords. My lords, which has resulted in wrong, the perpetuation of the wrong committed by the respondent number 1, 2, and 3. my
So
lord.
it is now complied with?
Yes. So the club matters.
Club matter, my lord, it is covered also, my lord.
Same order.
Yesterday also, your lordship.
Similar matter we have passed.
And they have conducted illegal activity, we have registered FIR also against complainant.
Will, only because we'll like to have in the same lines of.
Please. My lords, one request if I may, my lords. In this particular case, my lords, what has happened is the endorsement issued by the respondent number 4 and 5 to me in response to my representation, that was only oral, and one cryptic endorsement was issued that has been challenged in the writ petition, my lord. And in the writ petition, direction was issued to R1 to R5 to comply with the direction, my lord. Only R1 submits the compliance affidavit here, my lord, before my lordship.
He is the jurisdictional inspector, my lord.
Is the
Policy.
jurisdiction- Against him only my complaint situates, my lord. Grateful.
Number 57.
For the complainant.
Purna Veerana Tigri.
My lords, the complainants are land losers. This honorable court had directed payment of compensation. The directions are at page 32 and 33, my lords. Now, they have only released a part of the amount in January of 2024. Yeah, according to us, 50% of the compensation amount which is liable to be paid to us is still not paid.
After vacation, notice.
Very well, my lord. Great.
Third learned advocate, Mr. Rohan
Yes, my lord.
Virana Tigadi.
Grateful.
30th. Number 58.
The
SB Mukanappa.
complaint, my lord. The contempt petition is filed, my lord, is only insofar as relates to non-payment of cost and also non-payment of arrears of
Non-payment.
salary. The order passed by the Honorable Court, my lord, the page number 30, my lord. Page number 30, my lord. The respondent number 4, which has been served, the
Yes,
remain
what is
unrepresented, is directed
A2
to
is has to answer, my lord. Accused number 2, Lakshmi Narasimha Vidyalaya Samstha, it is an institution.
It is
They have
private institution.
private institutions.
Appeal is filed.
Still file.
You are not appealing.
Direction is against
But we
A2
have seen, but you are appearing.
for the pro forma fund.
No, you are directed to initiate appropriate proceedings against respondent number 4.
Malali.
Notice after vacation. Learned, you are accepting notice.
Yes.
Government advocate, Mr. Mahendra, accept notice on behalf of respondent number
Respondent number 1.
1.
30th May. Still number 59. Mr. KV Narasimhan.
My lord, appearing for petitioner, my lord. My lord, complainant herein has filed a writ petition in 390 of 2010, my lord, challenging the communication passed by the respondent bank, my lord, stating that the respondent service has to be treated voluntarily retired, deemed to be voluntarily retired, my lord. The said communication has been quashed and directed to reinstatement, my lord, by this honorable court. My lord, despite of me making submission, making representation.
After vacation.
The directions issued by this honorable court is at page 13, my lords.
Well, like today I filed my wakalat, my lord.
This
Big
honorable
next
court
time may
has.
be granted, my lord. I filed my complaints affidavit. Today I filed my wakalat.
Wakalatnama. Learned advocate, bis so and so and appears and prays time to file Wakalatnama. Put to be listed next on 24th of April. Within which time it is expected that the order under contempt shall be complied with by the respondent accused.
When I am representing complaint, the order in view is dated 22/9/23. He passed in WP 50/55 of 23. There is a direction to the Assistant Commissioner to dispose the appeal which was filed by us. So far, no order has been passed. Appeal is not considered. Therefore, I appeal for this honorable court.
See that appeal is
Please.
disposed, notice written, second week of after reopen.
I accept notice for R2.
Learned government advocate, Mr. Mahendra, accept notice on behalf of this one.
R2.
R2. Yes.
R2, R1 is the person who has disobeyed.
Notice
this
has to
order.
go.
Notice, show them
When the bat is posted.
in the second week after reopening. That is, let us give the date. 3rd June.
Number 62.
62, I am Dr. Sujata Durgekar appearing for R7. I have not received a signed copy of writ appeal yet.
After 3 weeks.
Number 63.
Consideration.
ಅಲ್ಲ, ಇದರಲ್ಲಿ by way of an interim order, virtually the final relief has been granted. So that's why we are in appeal.
I'm taking notice for the private respondents.
By an interim order, the respondent has been directed to conduct fresh psychometric test in respect of the petitioners.
But the learned judge has said,
Yes.
kindly see page 34, last paragraph.
34, yes. That is such a
had
representation is
said
given,
that,
the same
huh?
would be considered. But
Huh?
then in the
Given.
next page, he says, in my view, it would be appropriate to direct the BMRCL to conduct a second psychometric test after notifying the petitioners about the manner in which the psychometric test is to be conducted. The petitioner shall thereafter appear before the psychometric test and the BMRCL shall act in accordance with such psychometric test. By an interim order, sir, such a direction could not have been granted.
Third learned advocate, Mr.
Harish NN.
And notice to the respondents.
I take notice
Enable on 5th of.
You appear for respondent.
For the respondent, private respondent.
My learned friend is
5th of June,
accepting.
learned advocate, Mr.
Parashuram,
appears for.
the private respondents.
Private
All the respondents are private respondents, 1 to 32. A short date may kindly be granted.
Remain state.
My lord, in a similar matter, my lord, your lordships have directed that the test be conducted and the result be kept in a sealed cover.
No,
That
what is funny, how can that interim order be granted to direct conducting the test, psychometric test?
My lord, the learned single judge was of the opinion that once the test is conducted, my lord, may I just prize your lordships? My lord, what had happened was, my lord, my lord, there was no cutoff given. My lord, the test was conducted arbitrarily without even notifying the students of, my lord, the kind of test that is going to be conducted. My lord, while looking at all of this, my lord, learned single judge had said, let the, my lord, writ appeal 63.
Learned notice, so and so waves notice, learned with for the appellant press for interim relief to submit that the order of the nature and kind passed by learned single judge is of mandatory character and it is and it is directed to hold the psychometric test for the petitioners who are found to be not eligible.
They had failed in the psychometric test. They have been given a second opportunity.
The test itself, they have
We
failed.
already
Second
failed
test,
in the
yes.
They have already failed in the.
To prima facie, the order of the kind could not have been passed by a single judge. Therefore, by a paid interim.
Well, against the similar order, your lordships have held, my lord.
Till the next date.
It may kindly be expedited. The hearing may kindly be expedited because the recruitment
Against
is
the
at
very
stake.
same order your lordships have held, my lord. Writ appeal 63 is against the very same order.
Even that we will take. up the same
Because we need to go, we need to complete the recruitment process. That is our only anxiety.
This is a fresh order, independent order directing the
just for the failed candidates.
Failed candidate.
My lord, because, my lord, I'll tell you lordships why, my lord. My lord, we,
What I said.
my lord, even without giving us, my lord, even the basic guidelines on which the test is going to be conducted, my lord, the test was held.
Annexure G
But
may
on
kindly
that
be
basis,
seen, they have
after
only
appreciating
produced.
all of this, I don't have the papers on me, my lord, I've not been served. Lordships may kindly appreciate this. My lord, without even telling us what the cutoff, my lord, this is not a competitive exam, this is a basic criteria exam. But without telling us what the basic passing marks is, my lord, the examination conducted, my lord, the appellants before your lordships have mistaken what is a competitive exam and what is a cutoff mark, what is a basic mark passing examination. They've conducted as though it is a competitive exam.
But even finally, this order could not have been passed, probably.
My lord, you
See on that, we are not closing anything, any argument.
my lord, the livelihood of several candidates are at stake, my lord. My lord, let the psychometric test be conducted and be kept in a sealed cover. My lord, we're not even pressing for it. My lord, similar audio lordships.
Mandatory order cannot be passed in the similar.
My lord,
case
63 of 2024, my lord, we have taken the same
2024.
view.
Sorry. Yes.
Date may kindly be fixed in the next week or something, because the recruitment process has been held up. That is my only anxiety.
What process? Only we have stayed this part of the.
Very well.
Just we have, so rest of the things will not.
My lord, then nothing will remain for me, my lord. Lordships may kindly appreciate. Nothing will remain. I am rank 1, my lord. I am rank 1. I am in the select list. My lord,
Everything remains so long the main petitioner remains.
My lord, then your lordships may, my lord, please appreciate this, my lord. My lord, I am rank 1. I am rank 1 in the competitive examination. Lordships may not close the door for a person who has secured rank 1.
So if you succeed, then again we'll direct to.
My lord, my lord, kindly appreciate, my lord. Much water would have flowed, my lord, under the bridge before, my lord, the matters heard. My lord, may I just request your lordships, my lord, that let the cover come before the single judge, my lord. Let it not be open. We'll agitate our grievances, my lord. Only request, my lord. In the competitive examination, I am the highest marks. They were in the wait list. The candidates who was before your lordships in writ appeal 63, they were in the wait list and they are now selected. Kindly appreciate my grievance, my lord.
When we are convinced, right or wrong. That's all.
My lord, lordships may protect my interest, my lord.
No.
My lord, at least some seats be kept for me, my lord.
Delay is there.
Delay is there.
There is delay of 11 days, but since my learned friend accepted notice, therefore I thought.
Then we'll put post on 2nd of April. Return. You are accepting notice?
I'll accept notice.
Others are there?
No, only my learned friend will be representing all the respondents.
Extent of delay 73 days.
11 days of delay.
7 days.
11 days of delay.
11 days.
11 days.
11 days. So delay of 11 days is count down. There's sufficient cause made out from the governments made in.
Your lordship, allow me to file objections, my lord. My lord, nothing will survive for me, my lord.
So we are putting up now. Writ appeal may be listed for admission hearing. For hearing on 26th March.
26. Oh, obliged.
64. Comparative.
I'm not sure whether the interim order has been granted. It's not.
Okay.
For final disposal on 26th.
Is there any other party to be served?
No.
No
other.
Then what? Where is the question?
My lord, another writ appeal, my lord, your lordships have passed an order. I will bring that to your lordships, my lord. 26 March,
63 of 2024.
I complete pleadings by March on the
No,
next.
if there is nobody else to be served, then we will not resell from our order. Correct. We have gone down the delay and passed this order.
It may be, there's
That day you be
another
ready
writ
for
appeal,
argument.
63 of 2024, that may also be connected.
This side of the vacation.
My lord, your lordships may kindly, my lord, tag it along with them. There are
20
conflicting orders in the two writ
25th
appeals.
of
No,
April.
call that along with this.
25th of April.
So which is that connected matter.
Appeal
63 of
my lord.
2024, it was filed
Conflicting
by.
orders.
You have argued, you should not press more. Is it not? That may affect on the merits of the matter.
Pardon.
also.
May
We
I
understand
request for the
difficulty.
first
You are
week of
Anxious
April?
my lord, for the
Victorious.
clients, my lord, who will be left with nothing, my lord. That is my only difficulty.
Shortly, we are deciding that.
Date as well.
25th April.
If it
March,
can,
if your
if
lordships
it
may
can
give
be
a
in
date.
the first week
Both
of
of us,
April
my
at
lord.
least.
First week of April will not
First
be
week of
possible.
April. It's only because of the urgency, because we need to fill the post.
Twenty-seventh March.
27th March.
So deeply obliged.
Number 64, Mr. Chokareddy. 64,
Nobody doesn't agree.
65 agents, number 66, Mr. Srinivas TP. Srinivas TP.
Yeah.
My lord, here also mandamus is sought, my lord.
Yes, my lord. My lord, there is a sixth respondent encroached the public nala and he constructed building as well as the compound.
As in serial number 51, my lord, because here also writ of mandamus is sought.
No. In similar matters, we have issued notice, we have called for your similar nala matters.
Yes, my lord.
It's not simple matter, like some government property being taken.
Yes.
These matters are nala are treated differently by the Supreme Court.
He's constructed the building on the nala, my lord.
The nala. You see,
Notice has to be issued.
Lord, I take notice for
Srinivas.
TP Srinivas.
For the writ petitioner. Notice returnable on 15th of April.
my lord, I
1
take
to 5.
notice for
1 to
respondents.
5.
1 to 3, my lord.
1
1
to
to 3. Government is 1 to 3, my lord.
Lord, Mr.
Government,
M.R.
additional
M.R.
government
Subramanian.
advocate
Subramanian.
Nilofer Akbar accepts notice for
R.
1
Subramanian.
2 3.
My lord, Mr. R. Subramania for respondents 4 and 5, my lord.
He's senior advocate now.
Oh, I'm sorry.
She submits that because on the returnable date,
AG.
reply shall be filed. A response will be filed. Notice to the rest of the respondents to be served by the petition.
Number 67, stamp the patient.
I appear for this.
My lord, in this I pray for 2 weeks' time, my lord. My state, yes, my lord.
2 weeks.
The interim order may kindly be extended.
Manoj, I appear for HL Pradeep Kumar.
Interim order shall
I
stand
undertake
extended.
we undertake to file
Interim
wakalat
order
for
granted
our housing
earlier
board.
shall stand extended to the till the next day.
I appear for HL Pradeep Kumar on this matter, Manoj. I undertake to file wakalat for housing board. R5. Still number 68, Mr. Ravi Kumar GH, 68.
1 of years, 3 weeks.
Still number 69.
I appear for
By
the
government.
Finally,
revision petitioner. Lord, a short question is involved, Lord. The quarry is going on in the notified forest. The Honorable Division Bench, Lord, without appreciating the very land has been notified. Following the judgment of Kadugodi plantation, assuming that this area comes within Kadugodi, allowed the petition. Whereas this property is situated in Tumkur. And this has been argued twice, thrice.
Apex Court said no activity.
No activity within the, that too within the notified forest.
who appears?
Mr. Holla, senior counsel.
We'll take up the earliest possible.
Your last may kindly have it tomorrow, Lord, because I have been pressing for this matter.
Next week?
Next week we have.
Please.
Tuesday.
Top of the board, Lord, because every time it comes.
Other side is not here, otherwise we could have fixed it. We remind us on that.
Please.
So give. Any judgment?
Yes, yes.
Yes, yes, Lord.
You
Both
give
our
that-
months, okay.
2, 3
Give
judgments.
give that judgment before
I shall.
next day to learned court master.
Please.
Number 70, Mr. Anirudhanan.
I appear for the
70.
petitioner. My lord. As per the previous order, my lords, the comprehensive amended petition along with documents has been filed, my lords. I filed it on 29 January 2024. My lords, may I fix the date? Matter has to be heard, my lords. All the pleadings are complete in this.
This side or beyond? Last week of
Someday in April, my lords,
which year?
second week of April.
17 matter. So 16th April.
Very well. Grateful.
71 dispose seal number 72. Mr. Subramania Bhatt. SN Bhatt.
Please. It is already fixed. But this can be taken up Tuesday.
Pardon?
Tuesday.
Today, my lord, I am.
Tuesday. What is the, any urgency?
No urgency. Any urgency?
No, my lord.